1, and 4. Springs versus L&D Law. Appellant? How much time do you want?
5 minutes.
I'm sorry, what?
5.
5? Respondent?
Respondent
5 and 5. IB Children. Do you wish to submit since no one else is here? Okay, you can have 3 minutes. Ario Opportunity versus Harlem Premier. Appellant? Respondent? 4, 2, and 3. Hemstead versus Hammer Steel. Appellant, the first appellant? The other appellant? Respondent?
Yes, can I have 3 and 3 to address?
You don't get rebuttal time, so,
No, I have to address 2.
no, but you have to address them both in your same,
Then I have 6 minutes, please.
I'll give you 5 minutes. People versus, and you'll hear both their arguments before you have your argument. So People versus Harris, appellant? Respondent? 3? 5, 1, and 3. People versus Jacobitz is submitted. 630 West 52nd versus Fresh Inventory, appellant?
Appellant 4 and 1, please.
4, 1, and 3. People of the State of New York versus Northern Leasing, appellant? Respondent?
Also for the lawyer appellants, we get 6 and 2 as well.
No, okay, you're asking for 6 and 2. What are you asking for? I'm going to give 6 and 1, 6 and 1, and 5. People versus Amparo, appellant? Submitted. Nasta versus Raja Pasca, appellant? Respondent?
4, Your Honor.
5, 1, and 4. Atlantic Specialty versus Landmark Unlimited, appellant?
Maybe have 6 and 1, please.
Respondent? How much did you say, 2? 6, 1, and 2. People versus Peron, appellant? Respondent? 5, 1, and 4. People versus Serrano, appellant? Respondent? 6, 1, and 6. Draper Realty, there are 2 cases that are going to be argued together. Appellant?
2 and 1, but I would object to the arguing of together, Your Honor. 2 separate, distinct index numbers, 2 separate and distinct appellants. 2 and 1, 2 and 1 on both ends.
Respondent?
2 minutes in relation to each of them.
Okay, I believe they could be argued together, but I'll only request since you're asking for so little time. 2, 1, and 2, and 2, 1, and 2. Landel versus LifeBridge Dental, appellant?
Appellant 4 and 1.
Respondent?
Respondent 4, please.
People versus 4, 1, and 4. People versus Merrick is submitted. Marx versus City of New York?
I was told it was over here. We would take 3 and 1.
Respondent? 3, 1, and 4. Seaman versus City of New York is submitted. Hereford Insurance versus Independent Acupuncture is submitted. So the first case for argument is People versus Thompson.
May it please the court, Svetlana Kornfein for appellant Mitchell Thompson. Mr. Thompson's waiver of indictment is invalid because he did not sign the written waiver in open court as is mandated by the state constitution. The Court of Appeals in matter of Dolgan Elbert, 31 New York 2nd, explained that the term open court, as it has been used in ancient times, means
Counsel, isn't there a lot of evidence in the record that it was signed in open court? The fact that it was dated the same day, that both defendant and defense counsel signed a document confirming that defendant signed it in open court and counsel's present. The court also signed and approved the waiver stating that it satisfied all of the waiver requirements. Aren't those all indicia that it was signed in open court?
well, no, because the state constitution requires evidence of a written waiver that is signed by the defendant.
Aren't all the things I just mentioned evidence that it was signed in open court? Everyone agreed it was signed in open
Yes,
court?
but the record is inconsistent with
So you're
that.
saying that someone has to say somewhere, this is being signed in open court for it to be sufficient?
Well, I think the record has to show that it's on the record and when court is in session on that case. And here, that's clearly not the case.
What's inconsistent in the record that shows it wasn't signed in open court, apart from the fact that nobody said this is being signed in open court?
Well, because when the case was called and appearances were given, the judge said 3 copies of the SEI paperwork should be executed in open court. Counsel replies, yes, Judge, I do see that the copies are signed, which means that they had been signed off the records at some time and place before the case was called into session. So this is not consistent with the open court requirement, which Dolgan Elbert explains is a court convened with or without a jury to do judicial business. And it goes on to say that in an open court, a record of proceedings is kept, which is maintained by either the clerk or the stenographer. Here, that's clearly not the case. She says, are signed, the copies are signed. This is at the beginning. They've already been signed. Nowhere else in the entire colloquy in the plea proceeding do they ever come to discuss signing of the waivers. In fact, in the reply brief, in the extra additional statement of facts, when they talk about the waiver of appeal, which of course does not have an open court requirement, but nevertheless there is a written waiver, the court does not discuss that because it was already all 3 copies, all the waivers, the waiver of appeal, the plea agreement, the waiver of indictment, they were all signed before court was in session. That's inconsistent.
Counsel, can't we
with-
take into account the presumption of regularity that applies here?
Well, the presumption of regularity applies when the record is ambiguous or silent, as in this court's cases in Mora, Ramos, and Moore. But that's not the case here because the record is very unambiguous. The judge is saying should be executed, meaning it's an expectation that this will happen, and counsel is telling him it's already done.
But isn't
They are
that the
signed.
ambiguity, that the judge is saying that it should be done, and the ambiguity lies between the judge saying it should be done and the counsel's response? And in
Well,
that
no,
case,
but
we
she's
should
saying
take
it's
in-
already done. Sorry. Yeah,
okay.
she's saying it's already done. They are signed. So I respectfully disagree. I don't think there's any ambiguity in that.
Thank you very much.
Good afternoon, Your Honors. May it please the Court. Nathan Morganti on behalf of the people. Defendant validly waived indictment by signing a waiver in open court, and defendant's argument that the written waiver was signed in violation of this open court requirement suffers from 2 fatal flaws.
Counsel, would you address counsel's specific argument that the court saying it should be done and defense counsel saying it has been done would suggest that it was done before they were in open court?
Well, I think there's 2 responses to that, Your Honor. The first is that all defense counsel said was that they are signed, which only is a statement that at the moment that defense counsel was saying that they were signed. This was not a clear statement that these were signed out of court. And that at best or at worst makes this record ambiguous. And if the record is ambiguous, then the presumption of regularity would apply, and this court should find that the open court requirement was satisfied. And also refuting that, we do have 3 signed statements from defendant himself, defense counsel, and the judge in this case that the statement was signed in open court directly on that waiver as well. And so any concern that was caused by the statement there of the court should be overridden by those written statements that clearly said that this was signed with regards to the open court requirement correctly. And moreover, that's what this court needs to look at. The whole record and the totality of the circumstances is the standard that this court has pointed to in Mora and in Ramos and in the other cases that we cited in our briefs. And so even with though it is irrelevant that the transcript does not specifically say when this was signed, the totality of circumstances clearly shows that it was signed in open court. And if I could just briefly address defendant's reliance on the Dolgan-Elder case, what defendant is trying to do here is misrepresent this case into a requirement that the transcript say that this was signed in open court. And that's not what this court has held. That's not what the requirement is. It's the totality of the circumstances test, and the totality of the circumstances here clearly shows that this was signed in open court. If your honors have no further questions, we rest on our brief and ask you affirm. Thank you.
Thank you very much.
Our reliance on Dolgan-Elbert is for the Court of Appeals statement of what open court means, and we maintain the record here shows that it was signed off the record and before the case was called into session. So it doesn't really matter if counsel and the court all believed and signed off. In People v. Trulook, the Court of Appeals basically said that the lower courts can't take shortcuts, and quoting, for the sake of situational expediency. And that's what they're doing. They're signing it so that they make the whole proceeding go faster. It is a constitutional requirement. And just because the written paper says it's been signed in open court doesn't mean that it has, when the transcript clearly shows by the language they are signed, that it has not.
Counsel, if I may, you know, we know that there's a presumption of regularity. So my question to you is, how did you overcome that presumption? What, substantial evidence did you provide to overcome that?
That opening colloquy between the court and counsel where the court says they should be signed and she says they are signed.
Thank you very much.
So that's it.
Thank you. Your time's up. Thank you. Springs versus L&D Law.
Good afternoon, Your Honors. May it please the Court. Alec Niemand on behalf of L&D Law, PC, and Paul Laguerre, Esquire. The lower court, in deciding this motion to dismiss plaintiff's complaint, overlooked that plaintiff could not have alleged the necessary proximate causation element of a legal malpractice claim based on the underlying facts, because the facts, as alleged by plaintiff, do not rise to state a claim of retaliation, hostile work environment, or aiding.
Did the court specifically hold, though, that the reason the complaint was dismissed because there was absolutely no allegation of a causal connection between the earlier lawsuit and the claims alleged in the present lawsuit, that there wasn't even an allegation that existed there? It isn't the heart of this lawsuit that could have been alleged that there was a causal connection between the earlier litigation and the alleged retaliation in this case.
Yes, Judge Hellerstein did note that Attorney Laguerre did not put specifically that the
It was very clear that there was no allegation of a causal connection. I mean, he couldn't have been more articulate in saying that. And what would have prevented the lawyer from, at a minimum, at least alleging that causal connection did exist between the two suits?
I think what prevented, I can't speak exactly to what prevented the lawyer, but I can speak to that. Judge Hellerstein did go on to examine if the facts as alleged gave an inference of a causal connection. So even if Attorney Laguerre had specifically alleged that there was a causal connection, Judge Hellerstein still examined the adverse acts and determined they were either petty slights or trivial inconveniences, or that they were caused by something other than plaintiff's prior complaints. And take, for example, plaintiff alleges there's a smoking gun instance of his captain, Captain DiStefano, at the fire station, yelling at him, not to quote exactly, but "you're effed up, you went to an effed up firehouse and now you're effed up."
Counsel, isn't the failure to have put in an opposition, which could have made that causal connection, sufficient to state a claim of legal malpractice?
I believe it was a strategic decision made on behalf of my client in connection with discussing with the plaintiff in this matter that, based on the motion to dismiss that the underlying defendant served, which argued both that the adverse acts that plaintiff complains of are petty slights and trivial inconveniences, or were
How can we know if there hadn't been more robust allegations of that causal connection, that might have been, since there weren't, that might have been enough to allow the case to go forward? How can we decide that as a matter of law at this juncture, which is what you're asking in the motion to dismiss?
Well, at this juncture, plaintiff doesn't allege that there were any facts or any additional instances of adverse acts left out. So,
Yeah, but plaintiff alleges that the causal connection was not sufficiently laid out, that it was the act of the earlier EEOC complaint and the lawsuit that caused those subsequent acts, and those subsequent acts would not have happened but for the earlier lawsuit.
well, I think that is, and it goes to the point, the reason Attorney Legere felt strategic to amend the complaint rather than oppose the motion to dismiss is that multiple of the alleged acts that plaintiff faced had a clear other reason than plaintiff's prior complaints.
That sounds like defendant's argument, not a plaintiff's argument.
My client felt that there was not sufficient case law to serve in an opposition which would demonstrate that these acts as alleged were not petty slights or trivial inconveniences, or were legitimately caused by in retaliation for the prior complaint, when based on the allegations, going back to the comments that his Captain DiStefano made to him about being effed up.
That makes it sound like you never thought there was a viable lawsuit in the first place, in which case, why did they ever take on the representation? If there was no facts that could ever be alleged in your mind or the lawyer's mind that was sufficient, why would they bring the lawsuit in the first instance?
Yeah, well, this was an existing client who my client had represented plaintiff in a prior federal discrimination case relating to a different fire station that he was at. And during the pendency of that case, the plaintiff was very adamant about bringing this, the subject action.
We did it as a courtesy to the client. Okay, thank you very much.
Thank you.
Good afternoon, Kenneth McCallion. May it please the court. This is really a per se case of legal malpractice.
Counsel, what about the allegation that even if it didn't state there was a causal connection, those facts were clearly laid out in the complaint, and the federal court found that to be insufficient in its analysis of the facts, that nothing would rise to the level of an actionable conduct?
Well, he didn't allege it. The court could have implied it, but put the counsel to the test. It's plaintiff's counsel's responsibility to properly plead it. And the other side, in their motion to dismiss, said, okay, you got some of the elements of the cause of action, but you don't have causality. So if, in fact, counsel had done what every other lawyer does in this situation, which is to propound an amended complaint and explain to the court and highlight in that amended complaint exactly how it cures the allegation that causation is not there. In this case, the counsel left it to the court
Counsel, your adversary
guess.
seems to be raising the professional judgment rule. Why is it that we can't look at the facts here and apply the professional judgment rule, that the attorney, in his professional judgment, believed that an amended complaint was sufficient as a response?
Respectfully, I think it's really lack of professionalism per se and legal malpractice to throw in an amended complaint without, when there's a motion to dismiss pending, and not explain how the amended complaint.
So your position is that
Yours.
anytime a lawyer submits an amended complaint in response to a motion to dismiss, that that's professional malpractice?
No, it's done, the submission or the proffering of an amended complaint is done quite often, but I've never seen, and I've been around for a while, any case where even a short memo of law does not explain to the court how the amended complaint cures the
So
alleged
you've never seen
deficiency.
anyone submit an amended complaint to cure a deficiency raised by counsel?
Oh, it can be submitted, but he left it to the judge to guess how it might cure it, and it didn't cure it. I mean, the malpractice is twofold. Number one, he didn't explain how an amended complaint cured it, and second of all, the amended complaint did not cure it, where the motion to dismiss highlighted, it was almost in like invisible red ink, lack of causation, lack of causation, lack of causation.
What about the argument that there just wasn't a viable lawsuit there to allege that none of these things that occurred to him at the second station were sufficient to make out a viable claim?
It was actually, in our view, an extremely strong case, and counsel mentioned the smoking gun where the supervisor, Stefano, blew up at Springs, but when he quoted part of it, what counsel didn't quote is that Stefano specifically said, you call your lawyer, go call the union, no house is ever going to accept you. He specifically implicated the prior filings by Springs's lawyer, the 2017 complaint and the EEOC complaints. And that was, so is specifically referencing that the wrongdoing, the acts of retaliation, were specifically linked by Stefano himself and logic to the fact that no house will take you because of your prior filings. This was powerful, and these were not, I mean, well, the judge characterizes it as trivial. He would have, in our view, approved it, and even if after the decision came down, it's incomprehensible why Springs's lawyer did not, in view of this decision, move for reconsideration
Thank you.
or appeal.
Thank you.
Thank you.
You didn't ask for rebuttal time, so, yeah. IB Children?
Good afternoon. May it please the court. Rakaya Kifotes with the Bronx Defenders, and I am counsel for the appellant mother here, Miss M. We are asking this court to vacate the family's court order, which removed the children from their mother, because when the family court separated this family, they did so in a clear violation of the simple requirements of Family Court Act, Section 1061. The court provided no hearing, no notice, no motion before exercising what could be considered their most extreme power, to remove young children from their family.
Nobody requested the relief, right?
I'm sorry.
Nobody requested the relief.
Nobody requested the leave. This was over the objection of both ACS, who at this juncture had been involved in the family's life for well over a year, had been regularly monitoring the family, seeing the family at least twice a month, and the attorney for the children, who's there to represent the 2- and 4-year-olds' best interest and had also been assigned to the case since inception of the case.
Were there relevant substantive issues that did not get addressed at the hearing because of the failure to, at the court appearance, since there was no hearing?
Yes, Your Honor, so a hearing did precede the court's initial removal order. So there were many things that weren't addressed, especially on the initial day before the removal order was issued and these children were taken to the Children's Center. And then throughout the hearing, while a hearing did precede this and proceeded over a few court appearances, it's incredibly difficult for the mother here, because the burden was shifted to her to push back just against the court. And the court itself said in the very first appearance when it was removing the children, maybe I will change my mind after a hearing, but the burden is on the mother at this point. So even though there was a hearing afterwards, that clearly doesn't remedy the due process issues here, because it's unclear how the mother could have convinced the court that their own application was incorrect. And it's also difficult to address the court's concerns because it's unclear what exactly the court's concerns are. We are aware what ACS's concerns are. They wrote an order to show cause. We could address those in turn. But it's impossible for the mother here to know all of the court's concerns when there simply was no motion or no notice. And I think that was revealed in the court's both oral decisions, the more than one written decision, that concerns were popping up that there was no way that the mother could have been aware of those. And I think, the most important thing here, moving beyond the due process issues, is that there simply wasn't good cause to remove these children.
There was what?
No good cause to remove these children, as would be required to modify any order under the Family Court Act. The children have been safe at home with their mother for 9 months at that point. The CPS worker who'd been in the home repeatedly testified that she didn't have safety concerns for the children. There was no direct harm to the children explained, by the court. The court repeatedly emphasized her observations of the mother here without acknowledging the significant harm to these young children of being removed from their mother and then taken away both to the Children's Center and later to stranger foster care.
Thank you.
Thank you.
Ario Opportunity versus Harlem Premier.
Good afternoon, Your Honor. May it please the court. On this appeal, there are three sort of germane issues for this court, but they're inextricably intertwined. The first question is whether there was a basis for the lower court or the Supreme Court to grant re-argument in light of the fact that the plaintiff on re-argument took a whole new course and submitted new facts or new documents and new arguments that were not presented for the prior motion. The second question, as you know from the briefs, is if the court gets past that and say that re-argument was validly or legally permitted, then did the court err in saying, looking at the facts presented?
Let me ask you something, because on the re-argument motion, the argument being made, which whether it was or was not made before, was that there was an assignment. And there was standing to proceed because it was an assignment. And I'm looking at the assignment of the mortgage, which is very unusually drafted and not like something I've seen, because if it just said the notes assigned for the mortgage, that would be somewhat clear, but it doesn't say that. It says the mortgage was assigned, and then it says from Realty to Sharp, together with the note or notes therein. But where does it unambiguously say that the assignment, there was an assignment of the notes from the original owner of them to this plaintiff?
You're exactly correct, Your Honor. It actually doesn't. And what was presented on re-argument.
You're representing the
appellant, defendant appellant. Yes, you're exactly.
Oh, I'm sorry, because you were successful.
No,
you were unsuccessful. I'm mixing up the parties.
They were granted re-argument, but
I made your argument for you.
You've made the argument for me but I think it's an important argument to highlight, or fact to highlight, that on re-argument, they sort of crafted a package of these assignments. The first assignment, it's not dispositive, but we don't need to argue about whether or not you can assign a note or it was assigned a note, because it was clear. The second assignment did not assign the note. It referenced the first assignment of note, but even at that, as the court knows from the briefs, may know that plaintiff moved and pled on the complaint that it was moving on the note with allonges. At summary judgment, plaintiff's affiant said it
Well,
was the note.
arguably, plaintiff made both arguments below. The court decided it based on the allonge not being firmly affixed, but they do seem to argue that there was an assignment of the notes of mortgage in their initial moving paper.
Not quite, Your Honor, with all due respect.
That was what my
With
review
all due
indicated.
respect, because in the Talton affidavit that was submitted in support of the original motion, Talton clearly said it was the note and the allonges, and then with respect to the mortgage, Talton spoke specifically about the assignment of the mortgage. And the actual motion itself, the plaintiff's counsel's affirmation, was with respect to the note and the allonges. It's only on re-argument, this presentation of a package of assignments of mortgage. There's no document in the record that's a compilation of 2 assignments of mortgage. And even at that, to the point you generously made on my behalf, the particular assignment that purports to go to plaintiff did not assign the note to plaintiff. And when the court referenced the assignment for re-argument, in granting re-argument, they referenced the first assignment.
Since I was asking you the wrong question, what about the language that it's assigned together with the notes or notes therein? Why isn't that a sufficient indication?
Well, that language in the second assignment, in the 2020 assignment, comes at the very end of that assignment after it describes that it's just merely descriptive. It references the first assignment from the originating lender to the intermediary and describes that in that assignment was with respect together with the note. But the governing provision...
I'm going to let you have more time on rebuttal to address that.
Thank you.
Okay, thank you.
If it pleases the court, Rebecca Contz on behalf of the respondent. As far as...
Why don't you address the question that was meant for you and I accidentally gave to your opponent?
That's all right.
Which is that it is an unusual, it doesn't say assignment of mortgage and note, it just says assignment of mortgage, and the language is a little bit confusing about whether the note was or was not actually assigned.
So the now therefore paragraph on page 113 in the record, it says now therefore it assigns and transfers the above described mortgage together with the note and the indebtedness together with any and all guarantees thereof. That's the first assignment. And then the second...
Okay, go ahead.
And then the second assignment says that on page 116 says that it also says together with the note, it's therefore assigned. So
Yeah,
both
but it
of
says
them
the mortgage was
reference.
assigned from Realty Closing to Sharp together with the note. It doesn't say the mortgage was assigned from Sharp to plaintiff with the note.
The second assignment does say with the note therein. On page one, the one on page 116. It says together with the note.
Right, but together with the note follows that the mortgage was assigned from Realty to Sharp together with the note. So doesn't that create an ambiguity about what exactly was being assigned from Sharp to the plaintiff?
I think the intent of the assignment shows that the note was intending to go with the mortgage because the note is the.
But if you're arguing from, I'm sorry.
Sorry, I didn't hear either one of those.
If you're arguing from what the intent is, isn't that a question of fact that precludes our granting summary judgment in your favor? Whether we grant or deny the motion to re-argue, there's still a question of whether or not you're entitled to summary judgment. And if there's the kind of ambiguity in a document that we'd have to look to intent, how can we grant summary judgment on that?
I think that the language in the document shows that the note and the mortgage were assigned together. The language says that.
Where does it say that?
It's on page 116. It says together with the note.
Yeah, but that comes after the paragraph of the assignment from Realty Closing to One Sharp Opportunity.
I mean, it says with the indebtedness, and that's what Justice Kahn found, is that those assignments showed that the note traveled with it. There's nothing else.
Thank you.
In rebuttal, Your Honor, I just want to clarify that, in fact, Justice Kahn did not find that because the assignment of the mortgage that he refers to in his decision is the first assignment of the mortgage from Realty. It may have been oversight, it may have been inadvertence, but he does not refer to the actual assignment from the intermediary to the
The language
plaintiff.
she's quoting is the wrong assignment.
the language he's quoting is the wrong assignment. And secondly, you're correct, because if you look at the operative provisions of the assignment, the second assignment, it says all beneficial interests under the mortgage, period. It doesn't say that it's under the note, and that it includes the note. And you know, and then there's the related third, as mentioned on opening, this is not the instrument of facts on which they relied on initially in summary judgment. It's a sort of, let's go fix this, but let's go readdress this, I would say. But even in so doing, they're left with a problem that it's a question of fact. There's a question of fact as to whether the allonges were formally affixed. There's a question of fact as to whether this actually assigned the note. And there's a question of fact in either event, whether they satisfy or plaintiff satisfies UCC 3-202, which requires the endorsement, even if it's a bearer note, be on the instrument itself, the allonge, or be formally affixed. So in either event, we, on appeal, we ask that the court reverse the Supreme Court's decision and send it back down so that at least these question of facts could be vetted out.
Thank you.
Thank you, Your Honor. Rest on the briefs.
Hemstead versus Hammer.
May it please the court, Nicholas Calabria with Amity Demirs McManus for Hammer Steel and STS. This case is a product liability matter on summary judgment. The court denied the manufacturer and the distributor's motion in part by denying the dismissal of the strict liability case based on design defect, breach of implied warranty, and failure to warn. This is a 600-pound cement mixer that a manual was given to the plaintiff's employer, giving instructions on how to operate.
But were there any warnings on the mixer itself?
There were no warnings on the mixer itself, Your Honor.
So why isn't that an issue that would result in liability because of the failure to warn on the actual machine at issue?
Well, there were warnings on in the manual. The manual requested that the manual stay with the machine. That was
Why isn't
specific.
that a separate analysis, the manual versus warnings affixed to the machine itself? That even if you were correct in your argument that if they don't read it, you can't be held liable for the inadequacy of the manual, that you still could potentially be held liable for the failure to affix a warning directly on the machine about the dangers of tipping, which is what happened.
Well, there are dangers of tipping, but I also think that this fact pattern is that the plaintiff and his coworker, when they were loading this onto a trailer, placed it on the edge of this trailer, and that was the cause of why this.
Isn't that a factual issue? I mean, as opposed to an undisputed issue as to why or how it fell or what caused it to fall? I mean, how can we decide as a matter of law what actually caused it to fall in this instance? Particularly since the plaintiff doesn't even remember what happened.
Yeah, well, the plaintiff doesn't remember what happened, but there was a lot of testimony that he did know at one time what happened, that it was placed on the side and that he went to jump off the side of the truck and his clothing caught the machine, and because it was on the edge, it fell.
Right, and that's an argument you're making, but how can we decide as a matter of law that that's correct? Or what was the cause of what made it fall? Whether it be a design defect or the way it was placed or something else?
Well, I believe that what's in the record and the only possible scenario that everyone in the motions went with was that the plaintiff, it was placed on the side of on the edge, and that the plaintiff attempted to jump off the truck, and that's what, and he knocked it down.
This fact that you're relaying right now is undisputed by all of the testimony in the record? Is that what you're saying?
Yes, except for the plaintiff that says, I don't remember what happened.
Well, so then it's disputed, right?
No, he's the one, well, actually, his testimony told to other people, that's where they got that story from. He just forgot that story once he got a second lawyer and brought this case.
Or once he got over the condition that he was in when the
600 pounds
after the machine fell on him and crushed him.
Right,
That
600
might also
pounds
affect-
of it.
Yes. Well, I'm just telling you what the people around him, when he was in the hospital, what he was telling them. When he went to his first lawyer, that's the story that he told. And when that lawyer turned down the case, then all of a sudden,
Were there
he didn't
warnings
remember.
put on this machine after the accident?
Excuse me.
Were there warnings affixed to the machine after the accident?
Not this particular machine, subsequent years down the road, yes, there were. I believe the testimony is clear that the plaintiff stated that he never reviewed the manual. He was the superintendent on the site. He was in charge with the placement.
Thank you. You'll have time on rebuttal. But we are aware of your argument that he never read the manual.
Good afternoon. May it please the court. Patrick Lawless for the cross appellants. The labor law 240 claim should have been dismissed because it's well settled under the Court of Appeals decision in Topher and its progeny that an accident that happens while unloading and loading materials onto a flatbed truck is not a 240, is not implicated under 240.
Why isn't the mixer something that needs to be secured for the purposes of the undertaking? That, I don't think it's a black letter rule that things coming off and on a truck can never be the subject of a 240 claim. I think it goes to whether a sufficient showing is made that this is an object that needs to be secured while this is happening, while it's being loaded or unloaded.
This wasn't due to the lack of a proper safety device. The plaintiff himself testified he had all the instruments to secure this to the flatbed truck. Why he didn't do it, I don't know. But he testified he was provided with straps, tie downs, chains, and wheel stops to secure it. I don't know why it wasn't. There's nothing to indicate that after the mixer was placed onto the flatbed that it was unstable. The only testimony that we have is the testimony of the plaintiff's former fiance that he had told her in the hospital that as he attempted to jump off the flatbed that his clothing got caught, and that's what caused it to tip over onto him.
That's the same thing we were going to before. That's one version of the accident, but how can we accept that that is the correct version?
Well, there's no other versions of the accident, and there's no testimony to indicate that this was unstable. And again, there's nothing to refute the plaintiff's own testimony that he was provided with all the proper devices to properly secure this, and that he didn't do it. There's no other testimony that there was some sort of safety device that failed or caused this accident.
Thank you.
Thank you.
Please, the court. Nicholas Timko for the respondent plaintiff, Tyrell Hemstead. Addressing the warning claim, the manual itself, if you look at it, nowhere does it say this machine is likely to tip over when it's just standing.
Is there any dispute that this plaintiff never read the manual?
He says he doesn't remember whether he read it or not, but there's no
Right, but he
warning
can't-
on the
don't we have-
device.
Don't we have case law that if you don't read the manual, you can't bring a claim for something that was not contained in the manual if you never read it?
But our claim is there should have been a warning on the device.
Okay, and that's
This
a
is
different claim. So
this
is
is a
that your
construction
primary
site.
claim, that there should have been a warning directly on the device?
This is a construction site. Is it reasonably foreseeable that you're taking this grout mixer that's going to be covered with water and grout and cement and put it out there with hundreds of workers, and you're going to have a paper manual attached to it?
Let me ask you
It's
about
not-
that, because
it's not reasonable.
that also goes to the 240 claim and the argument made by opposing counsel that he had everything necessary to secure this mixer and make it safe and just chose not to use those. What's your response to that?
The response is, in order to show that he was a recalcitrant worker, he had no good reason not to use them. The good reason was he had things there, but according to the manual, if you look at the manual, it shows the hook. Bogle said the hook was attached. He was using a skid steer, and he brought it to the side, and he has to lower it down. If the skid steer doesn't reach all the way inside or whatever, he also said there weren't enough help. Bogle testified, the non-party witness, that the plaintiff was directing traffic because the truck was out of street. This is an open enterprise rent-a-car. People are coming in and out. And so the thing is hanging by one wire, in the middle, it's spinning. When he puts it down, sometimes it sits this way or this way or this way. It had to be adjusted. They were in the process of doing the things that they said they were going to do. So
Well,
he
sir,
had a very
on that point, do you agree with your friends that there is only one narrative of this accident, that the narrative they laid out is the controlling one?
Absolutely not. If you look at our expert, they submitted an expert, 3 pages, 2 of which say what he looked at, and 1/2 a page with some bullet points of opinions, with no analysis, nothing. Our expert has 25 pages plus another 10 of his calculations. If you look at page there's actually on page 1308 of the record is the exhibit where the defendant, Shelsky, marked the vertical center of gravity of this device. And it was in color in the record, but it didn't get reproduced. But you could see near the center image at the top, there's a dot there. He put a line in the little box. That's that. It's almost at the top. This is a very top-heavy machine. If it's put on a work site, it's up to the employer, it's up to the general contractor to know that this thing is a hazard for tipping, provide appropriate manpower to get it off of the lift,
Counsel,
get it set properly.
I'm sorry to interrupt you, but your adversaries have said that it's undisputed that this accident happened because plaintiff's shirt became lodged into the machine and his shirt pulled his 600-pound machine onto him. Is that accurate, that it's undisputed?
No, it is not. It is clearly disputed. The plaintiff testified he was when this thing hit him, it crushed him. He was taken to the hospital. He was admitted for a week or so. He was in an ICU for a while, okay? And somehow people claim he made statements of what he said. He says he doesn't really recall. But if you look at the photographs, that would be in the record on page 854 and 855, and you look at the machine, the top of the machine where the wheels are is on the trailer. The bottom is still up in the air on the trailer. The bottom crushed his chest. If he jumped off of the thing, he would have been in his vest caught or something, he would have been facing away from the machine and it would have fallen on his back. Yet it was his abdomen that was crushed. It was his spleen that was injured. It was his ribs that were damaged, okay? So it doesn't make sense. There's a lot of circumstantial evidence that he was on the ground, that the machine was up on the elevated surface of the trailer. The machine had to be adjusted in order to get it to be secured, and the machine falls on him.
Oh, sir, I'm sorry. So is it your position that this is essentially an unwitnessed accident, and we'd have to look to circumstantial evidence to ascertain how it unfolded?
Yes, Your Honor, it is because the plaintiff had severe injuries and because he doesn't recall exactly and no one was there. But we do know from the ambulance sheet, we know from the photographs on page 854 and 55, the position of the equipment. He was under that equipment. It knocked him down and crushed him. So how would he jump off?
And then your time.
Sorry.
I have one more question. What is so it sounds like the only evidence of how the accident occurred is what the plaintiff said when he was, shortly after he was injured. And you're asking us to disregard that, even though several people said that's what he said. Why should we disregard that?
Well, first of all, he didn't remember saying it.
I understand that, but other people...
His ex-fiancée claimed that when she saw him in a hospital in an ICU, he said something like that. His testimony was...
She asked you another question.
It may have been that.
So why should we disregard it?
Because there is other evidence in the record, including the incident reports that were done that say that the machine was unstable and it fell and it crushed him. There were 2 or 3 different documents. There's an incident report on page 1719 that makes that statement. There's another general liability incident report on page 1727 of the record that says they were loading equipment. After loading one of the pieces of the equipment onto the trailer, it became unstable, and Tyrell was not able to secure it, and it fell on top of him while Brandon was driving the skid steer. So there's a lot of evidence in this record suggesting other things.
Again, just on that point of how this accident happened, if you look at the plaintiff's expert report, the only scenario that's analyzed is the plaintiff jumping off the side of this truck with the machine teetering on the edge, and some of his clothing catches it and brings it down.
Well, counsel, if I may, how did you establish, through your expert, right, that the mixer was, not defectively designed or unreasonably safe? How did your expert establish that?
Based on the testimony of the designer of the machine that testified that he's the one that designed it, he's the one that manufactured it, that he had tested it prior to putting it in the stream of commerce, that he contradicts the plaintiff's expert about the angle that this would actually tip at. He said it would go to 10 to 15 degrees before it would become unstable. So there was testimony in the record by the designer of the machine that it was stable.
Thank you.
Thank you.
I'd just like to address counsel's comments. There was nothing in Mr. Ogle's testimony which indicates that there was any issue with placing the mixer onto the flatbed. After he placed it onto the flatbed, he was actually returning to pick up some more equipment, so he didn't witness the accident. The plaintiff had testified that had the accident not happened, he would have completed securing it. So again, there's no evidence. There's no evidence in this record that there was anything wrong with the equipment or that the plaintiff wasn't provided with the materials to secure this to the flatbed trailer. We have the testimony of the plaintiff's former fiancé as to how the accident happened according to the plaintiff, and there's no other evidence to indicate otherwise.
Thank you. very much. People versus Harris.
Good afternoon, Your Honors. On behalf of Appellant Mr. Harris, the Legal Aid Society by Andrew Alexander. Your Honor, at the time of this SORA hearing in July of 2018, Mr. Harris was 56 years old. He had been incarcerated for 25 years. Defense counsel at the hearing made points challenges and moved for a downward departure from the presumptive risk level to a level 2. And counsel did so to account for the many changes that Mr. Harris underwent over the more than 2 decades since his arrest. As to the downward departure argument, counsel relied on the fact that Mr. Harris had engaged in therapy, completed sex offender treatment, developed important pro-social skills that reduced—
Counsel, isn't that already accounted for in the guidelines, having completed therapy?
So the risk assessment instrument actually does not account for any of the rehabilitative programs that he has completed. The instrument does acknowledge the acceptance of responsibility and the participation in specifically the sex offender treatment program. But as the record demonstrated, there were other rehabilitative efforts on his part, and he states at the hearing, I was engaged in counseling sessions, I attended anger management therapy.
Isn't that sort of outweighed by the number of terror infractions he also received while incarcerated?
So the disciplinary history was raised as a mitigating factor here because, as I just stated, this was a person who was incarcerated for over 2 decades. He was approximately 31 years old at the time of the incident and was 57 years old at the time of the SORA hearing.
But that was after having committed 2 previous sex offenses, right?
That is the basis for the presumptive override to level 3.
Well, I mean, in terms of his 3rd incarceration that we're now speaking of, he had 2 prior stints of being incarcerated based on 2 prior sex offenses.
He did have 2 prior sex offenses, Your Honor, and the RAI takes account for those offenses. But to Your Honor's question about the disciplinary history here, over the course of 25 years, the record indicates that he had 11 offenses in total, so about 1 offense every 2.5 years. For the last 7 years of his incarceration, he had a spotless disciplinary record, and that's not a fluke. The record demonstrates that leading up to those last 7 years of his custody, he had gone through intensive rehabilitative efforts, as I've just stated. And so the REI, which I argue in my reply brief, is limited in its ability to account for the rehabilitative changes that have happened. Much of the REI's assessment is based on the individual's
characteristics as of the time of the offense. So in this case, more than two decades before. The REI also does not account for the individual's age at the time of their release, unlike, for instance, the static 99R, which is the most widely used risk assessment tool. Here, Mr. Harris is 56 years old at the time of his release, a factor that mitigates his risk of reoffense, but is nowhere accounted for in the REI.
Let's skip to step 3 then in Galati.
Excuse me, Your Honor?
Let's skip to step 3 in Galati then, the balancing test.
That's correct. So having established that there are mitigating factors that the REI does not account for, the argument that the respondent offers here is that this is not his first sex offense. And certainly that is a factor for the court's consideration. However, if that was where the analysis stopped, then what is the purpose of the SORA hearing? It's supposed to be evaluating risk as of the time of release. And so if we're going to simply stop our evaluation or our consideration based on just his conviction record, then it's hard to understand what is the purpose of the SORA hearing in the first place. It has
SORA
to.
hearings can also be updated with the passage of time, correct?
I believe Your Honor is referring to a petition for modification.
Right. So given that this SORA hearing is now 6 years old, and so part of the problem I have with this case is that the previous 2 times he was released, he immediately committed another sexual crime. So we don't. And then what's before us is the SORA hearing, which was in 2018, immediately when he was going to be released the 3rd time. It seems to me that the appropriate, what would be more useful is a petition for downward modification, which would tell us something about what's happened in the last 6 years.
That's certainly an avenue that's available here. However, there are issues with this particular SORA hearing that merits a review, both in terms of the downward departure argument and also in terms of the points challenges that were made by defense counsel that we address in our brief.
Okay, you have time, rebuttal.
Thank you.
May it please the court, Oliver Lee for the people. Good afternoon, everyone. Your Honors, the SORA court properly denied defendant's downward departure application based on his propensity for committing felony sex crimes within a month of his release from prison. While incarcerated for his latest sex crime, he received 2 Tier 3 sanctions for sex offenses. In total, he received 11 sanctions, 5 Tier 3 sanctions, and 6 Tier 2 sanctions. None of the factors identified by my adversary outweigh these factors and justify lowering his risk level.
Counsel, I know that counsel referred to the advanced age as a mitigating factor. My question to you is, what, if any, evidence was, presented to the SORA court, linking the advanced age would make the defendant less likely to reoffend?
So, Your Honor, I believe that the only evidence that was submitted to the SORA court were generalized studies. Nothing directly links those studies to defendant, especially since those studies don't directly apply to an individual that's that has committed multiple sex crimes upon his release from prison. This was his third rape that he committed, Your Honor. Your Honors, regarding defendant's challenge to his point assessment, this court doesn't even need to consider it because the issue is moot. Defendant's prior felony sex convictions subjected his assessment to an automatic override to level 3.
That was going to be my question for counsel, for defendant. We don't even have to consider those issues because it's an automatic override case, right?
Yes, Your Honor. It's not relevant under Gelati to determine his downward departure application. And Your Honors, if there are no further questions, I would rest on my brief. Thank you.
I'll start with Your Honor's point about considering the points challenges here. Here, there were challenges to a total of 35 points. So the board had...
But if there's an automatic override to 3, what does that matter, really?
Right. So what I wish to say was that...
downward departure?
I do think it's relevant for your consideration about the downward departure.
But
again,
It's not relevant for saying the point assessment was wrong, because no matter what, he's an override, right?
The point assessment, okay, so.
It's only
if I may begin.
relevant to another factor in the downward departure, is that correct?
Right, it's relevant to the consideration of the downward departure argument. Here, it's a difference-making amount of points that were being challenged. The presumptive score was 120 points. Defense challenged 35 points. Had they been successful, there would have been an 85-point total, a level 2. Now, that is, again, the SORA hearing went through the whole procedure of considering the points that were recommended by the board and that the people were recommending. So I think on appeal, Mr. Harris should get the benefit of this court's review of that assessment. Thank you.
630 West 52nd versus Fresh Inventory.
Good afternoon, Your Honors. May it please the court. In this case, a communication breakdown between a landlord and its former counsel led to the entry of a conditional order and then the dismissal of the action when the landlord did not meet the condition. Because the landlord has a meritorious claim and a reasonable excuse, the court should vacate the conditional order and reverse the dismissal. The record here shows that as soon as the plaintiff became aware of his discovery obligations, he began to comply with them. There is no showing of willfulness or contumacious conduct or prejudice to the defendant. A finding of a sanction under CPLR 3126 is premised on
This is a conditional order. And a conditional order means, what a conditional order means is that if you don't comply with a conditional order that makes clear that it will result in a dismissal, the court has the authority then to enforce the conditional order. Isn't that what happened in this case?
Yes, and that's why.
Is there any dispute that the Jackson affidavit was not provided per the date in the conditional order?
There's no dispute that.
Why didn't the court have the authority, putting aside reasonable excuse, merit, et cetera, the authority to enforce its order that it had validly entered?
The court should not enforce the order because there's no evidence that the defendant, or excuse me, the plaintiff had any knowledge that the order was entered. There is.
Sorry, you're claiming that your counsel didn't, that plaintiff's counsel didn't advise it in January that a conditional order had been entered?
Yes, that's the claim. It's in Mr. Plotkin's affidavit. He did not have knowledge that the order was entered. He was not aware of the conditional order until after I was retained, and I showed it to him. That is the testimony that is in.
But the conditional order was entered after multiple other orders, so it's not the first order requiring the disclosure, right?
In fact, it was 18 months after commencement of the action.
There were other stipulations that became so ordered. The affidavit states that my client was unaware of his obligations, and therefore, once he did not understand the need to produce additional documents. My client's position.
Now, you talked about the hospitalizations. Am I correct about that?
Yes, I did.
All right. Now, the hospitalizations, they occurred, let's see, November of 2023, right?
November of 2023,
All right.
that's correct.
Then a month later, there was a so-ordered stipulation agreeing to do certain things, right?
That's correct.
But the conditional order wasn't even entered until what, January 2024?
The conditional order was entered on January 16th of 2020.
Okay, so I was just unclear when you said that there was a breakdown in communication, because obviously somebody had to communicate. You was in the hospital in November, some communication, there was a so-order stipulation a month later, and then we know what happened after that.
Right, and my client's position, as reflected in its affidavit, which is not disputed in this record, is that he was unaware of the entry of the stipulation and the conditional order, and did not become aware of.
We have cases that say when a client claims they're unaware of what's been happening in the litigation for years, all of a sudden they get to be excused from everything that happened in that litigation?
There are no cases that I can cite to Your Honor that say that.
There aren't any cases that say that.
And I haven't.
And that's your primary argument, right?
Yeah, my primary argument
You could ignore
is,
what your lawyer's doing for years and then all of a sudden say, I didn't know what my lawyer was doing. And then you're off the hook.
I appreciate the court's concern that that would become an
I'm
obvious.
just curious if there were cases that said that's viable.
I didn't cite any in my papers because
Thank you.
I found none.
Thank you.
I see that my time is up. I will reserve my 1 minute.
Good afternoon. May it please the court. Patrick Robson on behalf of Respondent Trust Direct. Your Honors, with respect to the record, there is ample evidence that the plaintiff himself was actively involved in discovery in this case, was aware of certain discovery obligations, and I think we're somewhat parsing.
And what makes that clear in the record?
In the record, you'll see, Your Honor, first of all, that Mr. Plotkin sat for a deposition in September 2023, in which he gave extensive testimony about the fact that he was in possession of documents but had refused to hand them over. You will then see in the record at 263 and 265 instances in which plaintiff's counsel said he was not prepared to execute the third stipulation because his client objected to a physical inspection of the property. And then perhaps most blatant of all is the final Jackson affidavit that was submitted after the case was dismissed, in which Mr. Plotkin claims that all of the work he had done, supposedly in satisfaction of the court's prior orders, was done with his prior counsel, that he'd searched 3 different homes in 2 different countries, that he'd had his assistant conduct extensive searches for documents, all of which was done before the conditional order was entered and before the case was dismissed. So the idea that this was a plaintiff who brought this case who was totally unaware of his discovery obligations, I think is belied by the record. Whether or not he was aware of what constitutes a conditional order under New York law, that may not be clear from the record, but he certainly was involved in discovery and certainly was involved in dilatory actions that meant that 3 different orders of the court, the March 2023 order was not complied with, the 3rd so ordered stipulation was not complied with, and the 4th so ordered stipulation was not complied with before the court entered a conditional order. So there's ample evidence of that. With respect to the hospitalizations, the court mentioned those only involved hospitalizations in November, and the court's entry of a 4th stipulation was specifically to address delays incurred allegedly in connection with that hospitalization. So by the time we get to the conditional order, it's clear that there's a pattern and practice of non-action or delayed action by the plaintiff himself in complying with the discovery obligations. Finally, with respect to the position that the plaintiff somehow substantially complied with the order, that's an allegation that he substantially complied with the court's order by virtue of a Jackson affidavit that was submitted on a motion to vacate the dismissal order. And in that affidavit itself, it's our position, and the court recognized it, that there's no evidence of a search with respect to the original document request. That's paragraph 2 of
Thank you very much.
our affirmation. Thank you.
Thank you, Your Honor. I just want to take my rebuttal time to first cite to paragraph 14 on page 201 of the record, where you'll find Mr. Plotkin's statements about what he was aware of and he wasn't aware of. I would also urge the court to consider that the conditional order, in the sense that it made the sanction for failing to comply with it, the dismissal of the action was an unnecessary remedy. This is a plaintiff who still bears the burden of proving his case, and a lesser sanction such as determining an issue against the plaintiff.
But in that case, wouldn't your remedy have been to appeal from the conditional order?
Instead, what I did was move to vacate it. So the court below could have the opportunity to do that, given my client's unawareness of the order, and having moved to vacate it and having that motion denied, I believe I have the right to argue that it was inappropriately issued. Thank you.
People versus Northern Leasing. Is there a third lawyer that was here on this?
I thought there was another appellant's counsel.
Guess we're going forward without?
That may be him now.
I would have gone forward. Okay, go ahead.
Thank you, Your Honor. Good afternoon, Your Honors. Jason Serrano on behalf of the Northern Leasing appellants. The Court of Appeals has directed a three-step process for calculating restitution. Number one, how much was paid? Total. Number two, what was the total benefit received by he who paid? Number three, subtract. Those are the three steps that were pronounced in the Zit-Zikalisi case. I hope I got the pronunciation right. Back in 2007 from the Court of Appeals, citing the Lama case from the Court of Appeals, and that's been applied by this court repeatedly, including recently in connection with the Wybush case. Those are the steps for restitution. There is no serious dispute, Your Honors, that with respect to the order that is on appeal today, the restitution order, the monetary relief order, the lower court did not do that. Instead, the lower court said, I'm just going to calculate the total amount that was paid. I'm going to skip step B, because it sounds like it might require too much evidence, and I'm going to skip step C of the subtraction. That's simply not allowed. That is not restitution. That is punitive. That might be disgorgement, but the court had directed restitution, and the Court of Appeals said that is not permitted. In Wybush, this court reversed a lower court's decision to do the exact same thing, stating this court must reverse because, quote,
Are you saying it's wrong for restitution to, in effect, return everyone to the status quo as if the leases weren't entered into, which is, in effect, what the court did? Are you saying it was error for the court to return their parties to the status quo that they would have been if the leases had never been entered into? And what's wrong with that?
So, Your Honor, I would answer that with two answers. First of all, I am saying that what the lower court did was wrong with respect to what you just described. I am not saying that, I'm not answering yes to Your Honor's question because I don't think, I am actually confident that the lower court did not restore the parties to the status quo ex ante. That is why the second step of restitution and the third step are required.
Why isn't it a return to the status quo?
So consider this, Your Honor. If I owned an apartment building with five units, conveniently for the five distinguished judges on this panel, and I leased each of you an apartment unit for $1,000 a month for 10 years. And 8 years into that process, I was found to have improperly charged you. There was a cap of $500 for the apartments. I violated a statutory cap, and you've actually been paying too much the entire time, and my leases are now rescinded. Restoring to you all of the money that you paid me for the 8 years worth of living in that apartment, without accounting for the value that everybody got for living in an apartment rent-free, is not permitted. That's exactly what the Court of Appeals said.
That's a very sanitized way of putting having built small businesses out of millions and millions of dollars.
Well, Your Honor, I think it's the same thing. I would have bilked each of you out of $500 per month in my example. I was not permitted to charge you more than $500. I charged you $1,000 a month for 8 years. I bilked you. That wasn't permitted. But what the Court of Appeals says is, here's how you calculate the restitution award. You can't simply say, give them back all their money, because each of them...
Counsel, that's not what happened. Let's cut to the chase here. How do we account for the fact that the Supreme Court did allow for a deduction here? And that was for the value of the equipment.
Yes,
Let's talk about that rather than all this other stuff.
Sure, Your Honor. We account for that in two ways. Number one, the reason the court gave that amount was because...
Yeah, $373.59 per unit.
The reason the court gave that amount, Your Honor, is because it was instead of ordering everybody to return their equipment. Back to Justice Kern's question, to go back to the status quo ex ante, none of these lessees would have their equipment. We would have the equipment, right? And instead of ordering the return of the equipment, the court said, I'm not going to do that. I'm simply going to account for the residual value.
A fraud claim should be the same as a contract claim. Because let's say you enter into a contract, which is what you're saying, and it's breached. You get put back into the position you were in. This is a fraud claim. The court found that there was fraud here.
Right.
So shouldn't the restitution allow them to be put back to have been in a place with, what's wrong with letting them be put back in a place that they would have been if they'd never entered into these acknowledgedly fraudulent leases.
Respectfully, Your Honor, I agree with the proposition, but what happened here is not restoring the status quo ex ante, because the status quo was none of them had the use of this machine for all of the years that they had it.
So you're saying the court should have had a hearing on what the value of the machine
use
was
of
to each business during the period?
That certainly would have been appropriate. There may be ways of shortcutting that. You can compare the value of the lease.
And how would you determine for each of these individual leases what the value of them, of having the machine during this period was?
Well, in the GE case, Your Honor, that's exactly what the court did under the exact same executive law. They had everyone submit an affidavit who said they were overcharged, and you can compare it to what an actual lease should have cost, the properly priced lease. That subtraction at least would account for the benefit that was conferred upon the lessee. There was none of that. There wasn't a dime accredited for the use of the machine for free.
But the court did subtract the value of the leased equipment.
But that's because we're not getting the equipment back, Your Honor. That's not.
Oh, I don't think so. No, let's go back. 373.59, we agree with that. So the court, implemented this set-off even though there was some equipment that was never delivered, some equipment that was, not functional. So what about that?
Your Honor, all of that residual value that was returned was in exchange for not requiring the lessees to return the equipment. But each of these lessees had years of use of this equipment for free under the order. That's not
We understand your argument. Thank you very much. You have time to rebuttal.
Afternoon. May it please the court, Robert Freilich on behalf of the lawyer appellants, Mr. Joseph I. Sussman, PC, Joseph I. Sussman, and Eliyahu Arbabad. Your Honors, at every step of this case, the lawyer appellants have been deprived of the usual privileges that are afforded every other litigant in the state of New York and probably throughout the country. To begin with, the motion court below issued the liability order, finding the lawyer appellants liable for commencing actions which the motion court said were objectively baseless. When we went on appeal, this court refused us oral argument, and there was a very large record, multiple appellants, the respondent's brief, a 30,000-page record. Without oral argument, there was one thing I wanted to say at oral argument, which I want to say here, which is the linchpin of the liability order stems from the motion court throwing out all of the lawyer appellants' evidence as hearsay. The motion court ruled that the evidence was improperly authenticated business records. This was wrong.
Are you arguing liability again right here before us, or are you going to go to your arguments regarding disgorgement?
I implore your honors to revisit this. I will go to disgorgement right now, but I implore your honors to just review this. It's mentioned in our briefs, and I'll move on to the next point.
It's not properly before us.
Well, your honors, we were never given an opportunity to discuss it, and your honors didn't address it in the last issue.
That is the remedy.
Moving on, your honors, regarding disgorgement, the motion court's order of $9.3 million against each of the lawyer appellants jointly and severally is improper. It violated several foundational rules that are foundational principles of law, the first being the law of the case doctrine. The court ruled that disgorgement, in the liability order, the court ruled that disgorgement should be disgorgement of the fees collected from guarantors. When the lawyer appellants provided evidence of the actual fees they collected, which was minimal, they actually collected only less than $200,000, notwithstanding that they commenced tens of thousands of actions.
You're saying law of the case, but what specifically in our prior ruling would have prevented the court from fashioning the remedy it did with respect to the lawyers?
Well,
what did we specifically hold in our prior case that you're arguing prevented the trial court from making the remedy it did?
Sure. Well, your honors affirmed the order in its entirety, and petitioners didn't seek to modify the order. They didn't appeal it. They accepted it. In fact, the relief they requested was the relief that the motion court granted, which was disgorgement.
Right, but what you're saying that the trial court then did something that was inconsistent by clarifying its prior order. What in our language prevented them from issuing a further clarification when it was remanded?
Well, the court affirmed the relief.
We didn't have that issue before us that we have now because nobody was discussing that issue at that point. So it doesn't appear that we made any ruling on the appropriateness of the remedy at that time.
Well, your honors did make a ruling on the appropriateness because your honors ordered that the order be affirmed, and the court, the motion court, proceed with the remedy that it had already designed. I mean, categorically, it should proceed with the remedy that it had previously stated.
You're saying they were then, the trial court was then bound by exactly what it said before, it had no flexibility to do anything different?
Absolutely, Your Honor. If someone wanted to, the trial court and petitioners don't get to do it ad hoc on the fly and say, well, we don't like what we got before, now we want to change it, notwithstanding that we've been through a round of appeals and this court has affirmed it. When we presented evidence after this court had affirmed the motion court's order, the evidence showed that the lawyer appellants didn't collect that much money in attorney's fees. But that's just the fact. That means the remedy of disgorgement at best was.
Right, but we didn't make, and I'm trying to ascertain how you think we made some ruling one way or another in the prior case as to what the scope of the remedy would be that would prevent the trial court from fashioning a remedy that made you disgorge the fees you actually recovered in the lawsuits.
Your Honor's understood that the specific issue wasn't briefed heavily because the remedy was most of the attack was on liability itself, but the court affirmed the entire order, including categorically what the remedy should be. And even if this court goes beyond law of the case, and I just want to be clear on this, the Sussman supplemental aff explained so many of the categories of work that had nothing to do with collection actions. Specifically, a lot of the work related to just not doing collection actions at all, a lot of the work related to reviewing cases not to proceed with collection actions, a lot of the work related to...
What was incorrect? Go ahead.
Why isn't that related to a collection action?
But the only liability that the lawyer appellants are liable for commencing collection actions that are deemed fraudulent or objectively baseless. If they reviewed claims against guarantors and didn't bring those cases, that's not a fraudulent collection action. That's
Why was it improper for the court to find that that was part of the overall fraudulent scheme that was implemented in this case?
Because disgorgement is limited to the wrongfully gains earned from the fraudulent conduct. There's no fraudulent conduct if the lawyer appellant simply reviewed files and didn't bring a case. That's if the entire case were based on the lawyer appellants reviewed all the cases and never brought any collection actions, we wouldn't be here. It's the collection actions they brought that are supposed to be fraudulent. And the lawyer appellants, at the very least, should be entitled to have a hearing where guarantors should come forward and say, hey, I think I was defrauded. And the lawyer appellant should be allowed to present evidence saying, well, actually, we reviewed recorded telephone calls where you admitted signing the lease, you admitted you understood the lease. This is all the types of evidence that the motion court improperly threw out in the first point. But even if that was improperly thrown out for liability purposes, there's no reason the lawyer appellant shouldn't be able to reintroduce it here. The motion court just simply assumed all of this, anything the lawyer appellants did with respect to working for the northern entities should be recovered.
Oh, never mind, go ahead.
Okay.
It's okay.
Thank you.
Thank you, Your Honors.
Good afternoon, and may it please the court. Blair Greenwald on behalf of the petitioner's respondents. I'd just like to make a few points to clarify the arguments made by the appellant's counsel. As to
What about the argument that the court went beyond what was inappropriate in a restitution case by not making a specific determination about the value of these leases to the lessees during the period of the lease and deducting that amount from the total award?
So several points on that. One is that Supreme Court did exactly what it should have done, which is fashion a restitution remedy that appropriately restores the parties to the status quo ante and the way.
I'm sorry, the parties, plural, or just the lessees?
I'm sorry, restored the lessees and guarantors to the status quo ante, as well as.
Because the respondents certainly are not going to be in the position they were in before all of this, right?
They actually are going to receive the value of the equipment, which is what they had in the first instance. And I would like to make a quick point about that because the way that was calculated is that petitioners took the valuation from the respondents' own leases, which resulted in the amount of approximately $375 per unit. The evidence in the record also shows that that approximates the value of new equipment. Granted, this was discussed and found in the prior appeal. If the court is interested, the record there, 2015 to 16, which is an affidavit from respondent's vice president of sales, approximate the value of each unit of equipment at approximately $400. So the parties are restored to the status quo ante because the respondents get the value of the new equipment, which they had at the start.
the lessees and guarantors get the value of the money that they paid. So this was an appropriate remedy. Supreme Court appropriately exercised.
You're saying they were in effect paid for the value of the equipment?
That's
the entire
exactly
value.
right. And in
it wasn't
fact,
just the value at the end of the lease, it approximated the entire value.
That's exactly right. And in fact, Supreme Court really bent over backwards here to try to provide an appropriate remedy, in that the court, this also assumes that the equipment was all fully functioning, all delivered, which the record shows it was not in fact true for many units.
Your friends
With regard to the judgment as to the attorneys, what is your theory as to why the attorneys should have to disgorge fees they received for spending time deciding not to pursue a default judgment against some of the lessees?
So the attorney respondents were actually found liable for far more conduct than just bringing actions, specifically as this court's previous decision and order explains, and as Supreme Court's liability order also explains. The attorney respondents also placed harassing phone calls several times a week, threatening letters, threatening to destroy people's credit scores in order to extract settlements, and to otherwise force lessees and guarantors to provide payments. So their focus on the solely bringing of commencement actions is not appropriate here. And Supreme Court properly looked at all of this evidence. Supreme Court gave them multiple opportunities to submit any evidence in admissible form that would raise a triable issue of fact as to any further deductions they could make, appropriately considered the Sussman affidavit that was referenced, which did not provide any supporting documentation and provided bald estimates that even then did not explain why it was unrelated to the fraudulent conduct here.
Counsel, your adversary makes the argument that there are lessees who will stand to gain even though there was no fraud committed against them because of this wholesale type of restitution award. How do you argue against that?
Well, as a frontline answer, the fact that the liability order is not on appeal here and all the leases are rescinded means that the equitable remedy of restitution just means that everybody has to put back to the same place. So that is just law of the case and decided here. But in answer, to further answer Your Honor's question, the 6312 liability finding explained that it was this wholesale fraudulent scheme and all of these predatory clauses in all of these leases that rendered respondents liable here, and why everybody should be put back to their original position.
Your friends from Northern Leasing argue that the restitution order was based on two assumptions. The first was that every lessee was defrauded, and I think there was 1.2 million lessees altogether, maybe 248,000 at the relevant point covered by the restitution order, that every single one of those individuals was defrauded, and that not a single one of the lessees received any benefit whatsoever from the use of the equipment. How do you respond to that argument?
So I'll take each of those in turn. One is that the 6312 liability finding is just for persistent fraud. The liability order itself ordered rescission of all the leases, and it is that rescission order, which is not at issue here, that prompts the restitution order. But I would also note that every one of these lessees did get these especially predatory clauses in these leases. Respondents across the board practices and policies affected every single one of them. I'm sorry, as to Your Honor's second point, I'm sorry if you could remind me.
Oh, that the second assumption was that no lessee, not a single lessee, benefited from the use of the equipment.
Thank you, that's right. So that is irrelevant because respondents received back the value of the new equipment. So it doesn't matter, you don't need to separate benefit plus used equipment, rather you just give back the value of the new equipment. But in addition, respondents did receive the value of this and a substantial deduction of $103 million from the entire restitution award.
Thank you.
Justice Kern, very briefly, if I may, I'll be very brief. As it relates to Attorney Babad, why would he be subject to the full amount of disgorgement? Because, you know, he was an associate, he, you know, was on salary, and it's not even clear if he worked on all of the matters, you know, here.
Right, so first of all, that actually is law of the case because that was litigated in the prior appeal and this court affirmed his liability. But just to specifically answer Your Honor's question as well, the disgorgement award He is appropriately held liable because 6312 applies to any person. The courts have been clear that this does not need to
The amount, the
Oh, I'm
full
sorry.
amount. That's my question.
Thank you. Joint and several liability is the standard for equitable remedies like restitution, where someone engages in a concerted effort to do this. I would also note that, again, this is the record provided in the previous appeal, but this is also a reasonable assumption because there were 3 lawyers working at this law firm. There's no evidence that they were working on behalf of anybody else. They initiated 30,000 actions in 6 years. That means in 2014, they were commencing 32 new cases every single day. There was no evidence that he did work on behalf of any other client, nor was there any evidence that he did work on behalf of respondents that was unrelated to this scheme.
Thank you very much.
I'd like to pick up where Justice Higgitt's questions left off and my friend's responses. I believe her words right before the last follow-up questions were, it doesn't matter that there's a windfall. It doesn't matter that there was a benefit that was received by the lessees because we got the equipment back. That is the opposite of what this court ordered in the Wybush case. The Wybush case reversed because there was full restitution without accounting for the benefits received by those who owned the practice in that case. That is exactly what needs to happen. And I want to respond to Justice Kennedy's question. I understand that this is a party that was adjudicated through the executive process, albeit without a trial, to have engaged in conduct that was problematic. But this court consistently adheres to the requirements of looking at each individual order separately. This restitution order is flat out in violation of the Court of Appeals requirements for restitution. There is no ifs, ands, or buts about it. It clearly does not account for subtracting the benefits that were received.
We've heard the argument. Thank you.
Thank you, Your Honors.
Your Honor, just responding to a couple of statements that were made by petitioners. One, the attorney respondents were not liable. While the motion court may have made findings that the attorney respondents engaged in telephone calls and other harassing behavior, the attorney respondents presented evidence they were not involved in any of that. All they did was commence actions. This court...
But the actions they commenced were based on fraudulent conduct and fraudulent representation. So isn't that in itself problematic and something in which causes them to be liable for this kind of repayment of what they received?
They should be, assuming that of course we disagree that any of the actions were improper, but assuming that they commenced actions that were improper, they should be paying for disgorgement of the profits they received for wrongful conduct, which was just the collection actions. The only thing before this...
No, if there was no basis for the actions they commenced, then they should have to disgorge the entire amount.
Well, they're disgorging the amounts that they should be disgorging the amounts that they're paid for commencing fraudulent actions. The important thing to remember here is the attorney respondents commenced tens of thousands of actions. Most of the guarantors who were sued have never alleged any fraud. The only thing before this court in the prior appeal was out of the tens of thousands of actions were 82 guarantors who had made allegations.
Thank you.
Thank you, Your Honors.
Nasta?
Good afternoon. May it please the court. I'm Daniel Alter. I'm appearing today on behalf of the appellant. Your Honors, if I may, I'd like to address 3 points, hopefully as succinctly as possible, in today's argument. First goes to what I'd consider a rather troubling sanctions award that was issued in this case. Your Honor, if the court were to call its attention to page 112 of the record, it would see a big comprehensive arbitration clause. But notwithstanding that clause, respondents sued my client in court.
And you've cited the case law that says you're allowed to challenge in court when you're sued the veracity of those claims before you head off to arbitration.
Correct.
And that's exactly what
Exactly
you're
right.
doing. So you're arguing that it was inappropriate for counsel.
And I want to get to the inappropriate part because I think this all boils down to one focused question, which is when we moved to dismiss the lawsuit which they had brought in violation of the clause, and they had an opportunity to look at our papers and reassess their case, they came to us assuming the record doesn't really have a full-throated agreement to arbitrate, but nevertheless, they came and said, well, we might not object to arbitrating at this point. We had gone to the effort of drafting a full set of papers, and they had called the strategy for their case. What they were asking for was a full do-over. Oh, let's go out now and we'll go into arbitration on all the claims that we presented to the court. And we said, thank you, no. You have brought this case. We have, under the law, the right to challenge your complaint. So we're not going to concede to going to
You were
arbitration.
willing to go to arbitration afterwards.
I'm sorry?
You were willing to go to arbitration afterwards once the court
If,
made a ruling.
if, Your Honor,
The complaint
the complaint was sustained. The complaint, 3 of the 4 causes of action were thrown out. And the last cause of action was severely narrowed. So the notion that we would be sanctioned because we wanted to have the complaint adjudicated based upon the lawsuit that they brought and not give them a free do-over that would allow them to raise all the claims again in arbitration after my client went to the cost and effort.
Allowed to, though, now raise those claims and litigate in arbitration even though they were dismissed?
It's open question. Well, I don't want to get in.
It's not.
I don't want to get
not
outside the
clear.
record.
Okay.
Okay.
Yeah, I'm just curious.
Okay. Let me
Doesn't
say it's an open question that it will be an issue for
The arbitration.
resolution. Yes.
Not for us.
But, you know, simply put, we won. We won on that motion strategy, and they weren't allowed. The 3 of the claims were dismissed.
Do you want to address the contract claim?
Yes, I do. The contract claim is I would call the court's attention very quickly to the record, pages 6.21 and 6.22. And on them, specifically, you'll see paragraphs 66 and 77. Those are the only 2 paragraphs in the entire complaint that even mention the word damage with regard to the contract. And they're nothing but
Let me ask you
vacant
something,
boilerplate.
though. If you were supposed to give, your client was supposed to give certain information, and that information was not given, how can they even know how can he know how he was damaged because he doesn't have the information?
Because the allegations that they have made would be that he somehow sustained some kind of damage by not obtaining tax information, or that he was somehow deprived of a dividend, but he doesn't allege that ever a dividend was issued.
But how can he, that's the point. At this stage in the litigation, because he's claiming he never received any of those documents, how can he artfully frame that claim without first receiving the information?
Well, Your Honor,
He can't know what he doesn't know because he wasn't given the information he's claiming he was entitled to be given.
there are a line of cases that this court has decided along very similar grounds that we cite in our brief, which there was one case in the Gordon case where there was a alleged breach of a confidentiality agreement. They didn't allege any damages with any specifics. That case was dismissed. There was another case where there was
Right, but this is a case where once that information is obtained, damages might flow from that information that he doesn't now have because he never got those documents.
Your Honor, respectfully, if those allegations in 66 and 77 are permitted to state a claim for contract breach, there's likely going to be a slew of very, very open-ended and boilerplate contract actions. I'm sorry, Your Honor?
So that's never a good argument. With
Well, you have to look at it, those allegations,
If they're
because
saying the contract required information to be given, and you didn't give the information the contract required, anyway, you have time to rebuttal. Thank you.
okay, thanks so much.
Good afternoon, Your Honors. Please the court, Robert Angelillo, Arkansas Bakken for the respondent. And I want to address the sanctions issue first, because I think that's the primary argument that they're making here.
I'm sorry, what do you want to address first?
The sanctions issue.
Okay, well, let me ask you, there does seem to be case law, which is pretty clear, that in a circumstance where a plaintiff brings a lawsuit when there's an arbitration clause, the defendant does have a right to test the complaint and the sufficiency thereof before going off to arbitration, because it was plaintiff who brought the case into court. So that being the case, so what did defendant do wrong by saying, we want the court to test the sufficiency of the complaint, and once the sufficiency is determined, we'll go off to arbitration?
I think that they really minimized what actually happened here, and the timeline is important. The complaint was filed in May. In July, they raised the issue of arbitrating, and we consented to that. We said, okay, we'll arbitrate this case. They said, no, we're not going to accept that. So we said, okay. They've refused to arbitrate, so now they are no longer under...
What's wrong with that, based on the case law? To say they weren't refusing, they were saying they made it clear that they weren't just refusing to arbitrate, they were going to arbitrate once the court looked at the sufficiency of the allegations in the complaint, and they made clear that that's what they were doing. And I guess my question is, what was wrong with that? Timing, not timing, there's no question they made a motion to dismiss, and they wanted the court to make a determination on that before they went to arbitration.
Right, but that was to dismiss the complaint. So they made their demand for arbitration. If you look at their own analysis of Singer v. Jeffries, the analysis is prior to making a demand for arbitration, you can test the validity of the complaint. They made their demand. We said, okay. And they said, well, now we're not going to honor our own demand.
What's wrong with that? What's wrong with it?
The Supreme Court found something wrong with it.
I know, but I want you to tell us
what's wrong with it.
Is
what position are we put in now? If we file an arbitration...
The exact
and
position you were all along, that first the court will decide the sufficiency of the complaint, and after the court decides the sufficiency of the complaint, assuming it's not dismissed, you'll go to arbitration.
Well, Your Honor, the fact of the matter was we didn't have to go through that whole exercise.
You were the ones who brought the complaint.
Right,
You were the ones who... You could have gone straight to arbitration. You're the ones who brought on the court's jurisdiction by bringing a complaint and ignoring the arbitration clause. So
And we agreed to go to arbitration once they made their demand.
You
They
can't now
persisted.
complain that they're forcing you to expend the costs of litigation when you're the ones who started the litigation.
No, it's not the cost of litigation. It's the cost of a motion to compel arbitration, which, by the way, as soon as they demand the arbitration and we agree to it, they are no longer within the confines of CPLR 7503, which says a party that is aggrieved by another party's refusal to arbitrate. We didn't refuse to arbitrate. We agreed to arbitrate. So all of this was done without authority of a statute. And the cases that they cite, as I indicate, all talk about testing the complaint prior to the demand for arbitration. This testing of the complaint was after their demand for arbitration that we had already agreed to. So I think they're outside the confines of 7503A, and they're outside the confines of Singer v. Jeffries and the other cases that they cite. If I may quickly address the contract claim, I think Your Honor is exactly correct here. The defendant appellant is in the has peculiar knowledge of the information and documents that were withheld. We don't have that. And in fact, this claim is being arbitrated right now, and they can ask whatever questions they want about that. But at the time this complaint was filed, we didn't have that information. We alleged there's a contractual obligation. We allege it was breach. We allege damage. And a final point, if I may, this concept, and this goes back to sanctions, I apologize. This concept that they won this motion
We're out of time.
is really...
It's okay, but we understand your arguments about the sanctions. Thank you.
Very briefly, Your Honor.
Counsel, let me ask you a question about what was just being argued. What is your response to the argument that you made the demand for arbitration before you made the motion to dismiss, therefore giving up the protection of that case?
I'm glad you asked that, because it's respectfully nonsense.
Always happy to ask a question you want to answer.
Yes. We made the motion to dismiss, or in the alternative for a motion to compel arbitration, all right? Our primary focus was to dismiss that complaint when they wrongfully brought it in court. And we didn't want to be in a position where we somehow waived it by engaging in the litigation. So we said, if you're not going to dismiss, then we would like to invoke our right. But
and you made that clear at the outset.
Oh, absolutely. And the second point, this notion about, some kind of victimization of the plaintiff here, it was very important when we said, no, we don't want to arbitrate because we want to press our rights. They had every opportunity to file a voluntary discontinuance.
Thank you.
Thank you.
Atlantic Specialty versus Landmark.
Good afternoon. May it please the court. My name is Anthony Akampora from Ramon PC. I represent the appellants. If the court looks at the undeniable timeline in this case and the sequence of events, you're going to reach the conclusion that not only are there no circumstances under which plaintiff can obtain summary judgment on the facts as they exist now. But plaintiffs' claims, which are unpled and untested for agency, apparent authority agency, and ratification, fail and can never be proven. Your Honors, when you look at the timeline, according to plaintiff's complaint, my clients signed the indemnity agreement personally in front of a notary public in April of 2020.
Right, but that's not the claim they're pursuing at this point. They were pursuing that claim, but obviously they've abandoned that claim for purposes at least of the summary judgment motion, and they're now arguing the agency and ratification. So that's what we have before us in this appeal, so let's address it.
My point exactly, but you need to go back to that touchstone, because it's not until they make the motion for summary judgment that the issue of agency and ratification come about. It's not until James Napolitano submits his affidavit.
So we have to decide on the record before us whether or not, as a matter of law, they make out a valid claim for either agency or ratification as against each individual defendant.
But it's
So
ratification.
why don't they?
It's because at the time, this is not raised. So if agency, how can you have apparent authority that you only discover 3 years after the document is signed? How can
Let's talk about actual authority.
they've abandoned the idea of actual authority. They've abandoned the idea of actual authority.
I don't think they've abandoned it. I think if I ask her, she's not going to say they abandoned the argument of actual.
The only person in this case saying that he has actual authority is the agent, James Napolitano. My client says.
No, he's saying that he had actual authority to sign at a minimum on behalf of the company and on behalf of the president.
And he has no power of attorney, no email.
And he actually is also saying he had actual authority on behalf of Lynn.
And he says he had actual authority given to him by Lynn on behalf of her daughters. So there's
Right,
no.
so the daughters, he can't have actual because he didn't say he spoke to them. But as to Lynn, he's saying he spoke with her and she gave him actual authority. And he's also saying that as to Landmark and as to, I forget, Joseph.
And this is the classic case that this court and the Court of Appeals has decided for years and years and years. The only evidence that he has actual authority is coming out of the agent's mouth. There's no power.
We don't have any rebuttal from Joseph that he didn't have actual authority. And when we put that in context with the email and the desires to gain this contract.
I understand where you're going, Your Honor. I don't represent Joseph.
And Landmark. Are you representing Landmark?
I represent the Landmark
Well, Landmark
entities.
is the same situation, that there is ample evidence in this record that he did have actual authority on behalf of Landmark to sign these documents.
Let's assume that's
Because
correct.
Landmark goes with Joseph.
Let's assume that's correct, that Landmark does go with Joseph. Joseph says that these documents were forgery. Joseph doesn't say.
Is there any affidavit from Joseph saying that, or is that something that we get through the attorney's arguments?
There's a letter from Joseph in March of 2022 in which he says to plaintiff, this document was forged, I never signed it, and I never authorized it.
Counsel, that's why they're coming up, obviously, with the alternative argument because of the forgery argument. That's why they're making the agency argument. So the fact that Joseph might have denied signing it does not at all answer the question of whether Napolitano had actual authority with respect to Joseph and Landmark, which has nothing to do with whether or not he signed it.
I'm not worried about Landmark and Joseph.
Okay, so your only arguments are as to the three, the mom and the two daughters.
Correct. And as to them, all you have is the agent saying that he has authority, and that has never been good enough in this state to prove actual
So
authority.
you're arguing there's issues of fact as to his actual authority as to those three defendants.
As we have pointed out and repeatedly in our briefs, there are issues of fact everywhere. This motion for summary.
You've just somewhat conceded that there's no issues as to Napolitano and Landmark.
I said I'm not here
You're not representing.
worrying about Joseph Calvano.
And the company as well, right? Landmark.
You still don't have a scenario in which there's anything that shows actual authority.
Well, you have Napolitano's made a prima facie showing, not just Napolitano, but there's a lot of documentation in the record which clearly supports all of his actual authorities to everybody. Then maybe you're right, there's an issue of fact because they're actively denying it. but they've certainly put forth a lot of evidence to support their claim that everybody in the company was on board with this because this was the only way to get that contract and people wanted the contract.
The only evidence is that Mr. Napolitano says that, but my clients say, and Lynn Calvano.
They got the contract. They got the contract because they came up with a bond. They were never going to get that contract if they didn't come up with a bond. And there were clearly many discussions about wanting to get that contract and how they'd come up with a bond. So it didn't come out of the air, Napolitano's statement.
But those conversations don't happen with Lynn Calvano or Catherine or Heather. Those
There were
conversations happen
with Lynn, although she's denying it, but he's saying there were.
He's saying there were, and that's a triable issue of fact. Okay. In addition.
Okay, you have time on rebuttal. Thank you.
May it please the court, Amanda Maselli on behalf of respondent. I think that's something we haven't touched on that I'd like to touch on right now is ratification, because I think that there's one action of the appellants that regardless of anything else, we submit warrants that the decision be affirmed, and that it's undisputed that the surety sent a copy of the indemnity agreement to each of the appellants, and in response, they didn't deny executing the agreement until they were sued. Instead, worse,
Right, but then they did deny it, so why wouldn't that create issues of fact?
What's the evidence of ratification on behalf of Lynn and the sisters?
Certainly. So first, these sisters have admitted that they're financially affiliated with Landmark, their family-owned business, and Lynn is the owner of the company. So certainly obtaining a project like this, which everyone knew required bonds, is going to be financially beneficial to these parties. Additionally, the surety pursuant to the bonds had to make payments to Landmark subcontractors and suppliers, which would have ultimately been the responsibility of the appellants. So they were benefited to the tune of those payments as well.
But the ratification has to hinge on some sort of failure to repudiate the agreement, and we have here that they did in fact repudiate.
Well, they repudiated after we sued them. So initially they didn't repudiate, and the YH Lex Estates case, which is a First Department case, says that actually that period of time amounts to ratification if there's a failure to repudiate during that time. So I would submit that ratification is present here.
Do we not have some evidence in a record by one of the sisters who sent a letter which
Certainly.
could be deemed as a repudiation?
I don't believe that that's a repudiation. What they state in the letters is that they're no longer financially affiliated with the companies, and so that now they'd like to be removed from the agreement, which Justice Borak said very well on renewal to the preliminary injunction motion, which was this is not the response of defrauded parties. It's just simply not the response. Thank you.
Anything else? Thank you.
I'd like to address what counsel just said and your question, Your Honor. The letters are not dispositive because if you look at what happened, Joseph Calvano sends a letter that says, I didn't sign this document, it's a forgery. Summary judgment's granted against him on ratification. Lynn Calvano says nothing. Summary judgment's granted against her on ratification. And my clients send a letter that is a second draft, and if you look at the record, they were told that's the letter they needed to send to indicate this. I have not seen any citation to any authority in any court that says you have to raise all of your issues and all of your affirmative defenses at the point where you have been given a demand. We object. We proved that this is not our document. We never signed this document. And now I am faced with an insurmountable task of defending a claim that was never pled. We never got the ability to test what's going on. It was done on summary judgment. And until Jim Napolitano says, I signed the document, he denied that he had any knowledge whatsoever about in the indemnity.
Thank you.
Thank you.
People versus Peron.
You may proceed.
Good afternoon, Your Honors. May it please the court, and Kekshi Arandu for Louis Peron. I'll be focusing on the order of protection issue. No legal authority supports the issuance of an order of protection on behalf of Mr. Peron's son, Zion. Therefore, it must be vacated.
Was this issue preserved before the trial court?
So it wasn't preserved, but it's important to highlight in this case that Zion was actually never even mentioned on the record when the conditions of the plea were being discussed. If your honors look to pages 3 and 4 of the plea minutes, you'll see that the only person mentioned as being the beneficiary of the order of protection was Christine Stevens. So it's reasonable to expect Mr. Peron to be able to object to something that he didn't even know, he wasn't made aware of.
The court issued the order of protection subject to family court modification, so there was something known regarding children in common.
So yes, but I think it's important to recognize that, when the conditions of the plea are being discussed with Mr. Peron, he's under the understandable impression that it's only going to apply to Christine Stevens because that is what the court said, and that is what the prosecution said as well.
When the court mentioned that it would be subject to family court modification, what was the impression of who the family court modification would cover?
I'm not sure. I mean, Christine
Well,
Stevens.
I mean, at the time, we know that the complaining witness, at the time of the alleged incident, that the complaining witness was 6 months pregnant.
Yes.
That was known by the defendant as well, right?
Yes.
And that they had a child in common, right?
Yes.
And that the order of protection was going to be subject to family court modification as it relates to that child that they had in common.
Yes, but again, it's really important here to look to actually what is said when the conditions of the plea are discussed. Mr. Peron had no opportunity to actually say or to object to the fact that Zion was going to be the beneficiary of that. And so we can also look to the beneficiary of the order of protection.
Well, but if he had thought that the sole beneficiary of the order of protection was Ms. Stevens, then why wouldn't he or his counsel have objected to it being subject to family court orders? That would have been meaningless.
So again, we don't know why. So basically, whether it's due to misunderstanding or mistake or...
Wouldn't that have put him on notice that there was a child who was the subject of the order of protection?
Well, Christine Stevens was the partner of Mr. Peron, and so Mr. Peron could have been under the mistaken belief that it being subject to family court modification was due to the fact that Christine Stevens, his partner, the mother of his children, was going to be the beneficiary of the order of protection. CPL 5.
I just want to go back if I can. Now, defense counsel did indicate that there were some concerns about the issuance of the final order of protection. Am I right about that?
Yes.
All right. And then I think further indicated that, he would further discuss those concerns at sentencing.
Yes.
But that was not done.
It's not clear from the record.
Oh, it's clear. So we can go look at the transcript because it was either done or not. And I had the transcript. I don't recall any discussion about that.
So yes, there was no discussion about the specific beneficiaries of the order of protection, but that is...
Didn't he even specifically say, and the he, I mean, or she, the defense counsel said that the family court or modification and the order of protection would not preclude the disposition, would not preclude the defendant from taking the plea, correct?
Yes, but under the conditions of the plea that were discussed by the court, and that, again, only included Christine Stevens. And so if we also look to the statute, 530.13, that statute requires that the beneficiary of an order of protection be a witness of an offense for which the accused has been convicted. And so that's been interpreted to mean that the statute, that a court may only enter an order of protection for the benefit of a witness who actually witnessed the offense for which the defendant was convicted. And so in this case
Counsel,
here...
Your client also signed the final order of protection, which listed the child. Isn't that a waiver of any objections to it?
So he signed it, but I think it's reasonable for someone who is engaging in his first, a plea and taking a plea on his first felony offense to really just assume that the order of protection is going to be reflective of what had been discussed during the plea.
May it please the court, Noah Shamoy for the people. Your Honor, I can identify 5 more reasons why the order of protection should be affirmed in this case, and I'll be very brief, but the waiver of the right to appeal, this court has said, does apply to orders of protection in People v. Key and 3 cases that predate that. The waiver in this case included the CGI model waiver, which has been endorsed by the Court of Appeals, and the written waiver, which this court has repeatedly endorsed. So the waiver is solid. Second, my adversary now admits that it is unpreserved, and it is. They did say that they would speak about it before sentencing and have it addressed by sentencing. And at one point, it was actually said, the order of protection will not prevent us from taking the plea today. That was the defense attorney said that on the very same page as my adversary cites. The appropriate court to hear this request, of course, is the lower court. The subject to modification means you have the family court that can do it. People v. Nieves says you can go back to the sentencing court itself. But the point is, you want a record made for an appellate division court. It's been 2 years. A modification may have happened already. We do not know. Next, under the statute, we cite to both CPL 530 sub 12, which is the domestic violence statute for order of protections, as well as 530.13 sub 4A, which is for witnesses or victims who aren't family. I will simply stick to the one that my adversary mentioned and point out that the complaint charged endangering the welfare of Zion, the child in question, quote, they were all present and visibly upset due to the defendant's conduct. It also charged that the gun was in a holster on his right waistband. All of that's in the allegations in the complaint, which means, oh yeah, and the 911 calls, which were described by affidavit, described choking of the victim, the mother, as well as a brown gun being seen. Now, that means that the kids saw the gun. It doesn't matter that the kids saw the gun in the house and didn't see it outside the house, which seems to be the distinction my adversary is making. They're witnesses to the crime of him possessing the gun. So under the statute, it wouldn't matter when they saw the gun. They are witnesses for purposes of our prosecution. That the cops arrest him outside is entirely irrelevant. Finally, the argument itself at a certain level does not make sense to me because the defense does not say that the order of protection was inappropriate for the mother, even though as far as the gun is concerned, they're in the exact same circumstance. The mother was in the same room as those children. She was the one being attacked. They were the ones watching it. He's the one who possessed the gun. She wasn't there when the cops stopped him with the gun outside.
But there's no allegation that he brandished the gun during the attack.
It actually says that it was in a holster on his right side in the complaint. So it was not concealed. So if the court has no further questions, I ask that you affirm.
Thank you.
With respect to preservation, this court has reached this issue, and when this issue has been unpreserved, most recently in People versus Gordon in 2022, and the Second Department has as well in People versus Rosales. In terms of my adversary's argument that regarding the gun and its visibility, there have been the cases that I mentioned in my brief specifically discuss this issue, particularly when the crimes that form the basis of a complaining witness's allegations are dismissed. And that's exactly what happened here. All the crimes that form the basis for the allegations involving domestic violence were dismissed. And therefore, this court has decided that orders of protection in those instances must be dismissed. In terms of the notice issue.
Thank you. We'll read the brief and familiar the issues. People versus Serrano.
May it please the court, Allison Haupt for Mr. Serrano. This was a straightforward robbery case with all of the evidence gathered or capable of being gathered within mere days or weeks of the incident. And yet the district attorney's office sat for more than 2 years before finally pursuing charges against Mr. Serrano.
Well, their argument is that they were awaiting a federal investigation or federal cooperation agreement between your client and the federal agency, and that is a basis for them delaying any indictment.
Well, the district attorney alleged that in order to make out good cause, it is, of course, their burden to prove good cause. And when we go and look further at that explanation, we just see that it doesn't hold muster. Because at no point, number one, did they ever allege any sort of communication in the 2-year period from the time of which this robbery occurred and when they finally received a phone call from Detective Puga in May of 2014 where the detective is saying, what's going on with your investigation? So just sitting on your hands, just waiting for something to possibly happen is not enough to say that you've met your burden to stay in contact with the federal investigators. There are two justifications for what's happening in federal court. One is this possibility of cooperation. But in his reply in the lower court, the defense attorney alleged specifically that when cooperation was presented, Mr. Serrano immediately shot down, no, cooperation isn't a possibility. So the hypothetical possibility of a rejected cooperation agreement cannot justify 2 years of sitting on your hands.
Does the case law in this department say that the people have to give a detailed timeline of what they were doing while awaiting the investigation?
Reagan, the Court of Appeals case, is actually a wonderfully instructive case for this court to consider when it talks about here, that just sitting on your hands with an absence of information of what's going on. In Reagan, there was 1 year where they had spoken to an investigator about seeking DNA evidence and then sat for a year, and there's no information in the record about what did the DA do during that year. Reagan held that to be not good cause, held it that there needed to be dismissal of the indictment. It's their burden. When you have the burden of proving good cause, you have to show that you've actually done something about it.
Do they also have to prove that there was no prejudice to your client?
If there's an extensive delay, with respondent admits that this is an extensive delay, and if there's the absence of them proving good cause, which here, again, because of the absence of doing anything to confirm the lack of cooperation, there was absolutely no nexus, an interstate nexus, in order to justify a federal robbery prosecution. At what point did the federal government determine that? We don't know. They did absolutely nothing until Detective Puga called them and then learned, oops, at some point in this 2-year period, there was no federal nexus. If you fail to meet good cause, then no. The case law makes clear that those two factors, 1 and 2, there's no prejudice requirement. Additionally,
you just said that there was no nexus. What about the firearm? Because the firearm was what was at issue in the federal litigation, correct? That being that your client was a convicted felon under the federal statute and also possessed a firearm.
The gun possession was the Bronx prosecution. That's not related to what's happening here. And in fact, respondent makes no argument whatsoever about that gun investigation.
But the robbery charge here, was that not robbery with a firearm?
Correct, but if there's no federal nexus for the robbery charges in federal court, which we know that there wasn't and that the DA did absolutely nothing to determine that in the 2-year period, then there's nothing preventing the prosecution in Manhattan. And in fact, we know that's the case because when they finally got the call from Detective Puga and they finally were shaken alive to say, let's find out what's going in federal court, that's when they pursued robbery charges in Manhattan.
Well, didn't they move right after that, a month later, to get a search warrant for the phone, as well as to then a month later obtain an indictment?
They waited 2 years to get a search warrant. Their first search warrant was
once they
July 9th.
realized that no federal action was moving forward, they moved pretty quickly after that, correct?
You can't sit on your hands and just think, you know, at some point somebody might give me a call at some point in time and tell me something about a hypothetical investigation. And once you finally learn about it, move quickly, and that takes away any.
So your argument about what's fatal in the people's evidence is that they didn't set forth what they were doing within a 2-year interim when nothing was occurring.
My argument is twofold. One, they didn't meet their burden of proving good cause because we know that there was no cooperation agreement on the table. There's no information whatsoever about when they learned about it. We know that there was no interstate nexus, and at no point in time in 2 years did they do anything to learn that. But second and apart, at the very least, there needs to be remand for a Singer hearing, because all of this information was what could have been conducted had the court ordered a hearing. Because just having a 2-year period where you don't pick up the phone, where there's zero communication, despite the fact that your explanations for why there's a 2-year delay completely fall flat when you actually look into it, then if anything, at the bare minimum, there needed to be a hearing to identify that. The search warrant, again, Reagan is such an instructive case.
I'm sorry, I just want to be real clear before your red light goes on. You acknowledge, though, that the 5 Taranovich factors are the controlling test here, correct?
Yes, and those 5 Taranovich factors are the ones that explain why dismissal is appropriate.
And can you point to, what's the strongest authority you can point to that dismissal is warranted where there's a 2-year delay?
We include in our brief, in this point, numerous cases where there's a similar number of terms. One of them, even 15 months, where it's allowed 31 months, pretty close to 25, 22 months. They're all cited in our brief, and yet that is considered an extensive delay. Staley talks about 31 months being an extensive delay. And I would say that my adversary agrees that it's extensive.
May it please the court, Brent Yarnell for the people. The people have discretion to pause the prosecution for good faith reasons, and
But your discretion is obviously cabined by the obligations under the Constitution and People versus Taranovich. So yes, you have discretion, but within that context, right?
absolutely. And what
You have to establish good cause, right?
well, we have to establish that we had a good faith legitimate reason for the delay, and we did here. That good faith legitimate reason is that the federal prosecutors in the Southern District of New York were investigating the possibility of bringing federal charges for the same crime, and they were also
Sorry, we're considering bringing.
they were investigating whether there was an interstate nexus that would allow them to bring federal charges for against defendant over the robbery. And then they were also exploring the possibility of entering a cooperation agreement with defendant. And I would say that the 21 months that we gave them before we followed up in May 2014 was certainly reasonable.
So there was a nexus about whether, in fact, there were robberies that were going on an interstate level?
So we don't know why exactly they thought there might be an interstate nexus in the robbery, but I certainly think based on the facts that we know, it's possible that there could have been. So we know that defendant had interstate criminal contacts. For example, the gun that he purchased from a gun dealer in Virginia, and he told one of the detectives when he was being interviewed on July 31st that his business was to purchase guns out of state and then sell them in New York. We also know that he sold the jewelry. In this case, he said that he sold it for $1,000 to a person named Killa. And so based on that, I think it's, for an investigator, it's just, I think it's reasonable.
It took 2 years to make a determination about this nexus?
Well, we don't know what exactly happened at
Okay, so what did anyone in your office do within the 2 years to determine, to ascertain what was happening with this investigation?
Well, we don't have facts about communications between our office and the Southern District of New York, but we certainly know that the Southern District of New York was active generally against defendant. They brought charges against defendant over the gun possession case in June of 2013. Defendant pled guilty in October of 2013. Then he withdrew his motion. He filed a motion to withdraw his guilty plea in March of 2014, and it's 2 months later.
A year later. Right, so but between the time that he pled guilty and the time that he withdrew his guilty plea, what was your office doing?
Well, I just think we have discretion. We have discretion not to spend prosecutorial resources on a investigation and a prosecution that may become redundant if the federal prosecutors decide to charge.
What were you doing to ascertain that it would become redundant? What was your office doing to ascertain that?
Well, I think that we didn't have the burden to provide more details about what our communications were. It's clear that there was an investigation.
So in terms of establishing good faith, you don't believe that you had a burden to show what was happening within that time frame?
Well, we did show what was happening. I mean, we didn't show.
But nothing was happening.
No, that's absolutely not true. What was happening was that the federal prosecutors were conducting an investigation. They were charging defendant with a separate crime. We have the dates. And what we know is that we received notice that he didn't work out as a cooperator 2 months after he filed a motion to withdraw his guilty plea. So I think the facts here definitely show that there was a lot going on, and it's readily distinguishable from Reagan, where basically a prosecutor in the office just dropped the ball and didn't do anything about DNA evidence that obviously could have been prosecuted immediately. This is very different.
Well, but what evidence is that your office did anything to monitor it or to make sure that the feds hadn't dropped it or that it wasn't still alive? Is there any monitoring or once a month giving a call and finding out what's happening?
Well, we don't have facts about that, but what I would point out is that first of all, this is a serious charge, and I think that 21 months is an appropriate amount of time to allow the federal prosecutors to determine what to do with the serious charge. And second of all, you got to.
What is the basis for your determination that 21 months is an appropriate amount of time to give the federal prosecutors the time to decide whether they're going to proceed or not?
Without any information about what was happening in that intervening time.
Sure. So first of all, the factual question about whether there's an interstate nexus is a factual question that requires investigation. And second of all, negotiations over cooperation agreements, take time. Sometimes it just takes time to figure out whether someone really wants to do it. Sometimes they reject it initially, and then later they decide to do it. These things take time.
Argument that her client rejected being a cooperator from the onset of this prosecution.
Well, he claimed that he rejected it from the onset. That certainly doesn't mean that federal prosecutors weren't continuing to try to enlist him, even if it's true. And then moreover, even if you find that the first two factors weigh against us, you still take into account the second factor, the third factor, and the fourth factor. This certainly was a serious crime, and there's no doubt that he would have remained incarcerated regardless of what we did here, because we hadn't even filed charges. And so factors 3 and 4 certainly weigh in our favor.
You want factor 5 to break the tie in light of the presumption that if 1 and 2 are satisfied, that there is prejudice to the defendant?
Well, there certainly was no prejudice to defendant in this.
But isn't the case law clear that if elements 1 and 2 are satisfied, and particularly if there's been quote-unquote protracted delay, that the presumption is prejudice? Isn't that from Wiggins?
Well, what the case says is that if 1 and 2 apply, then defendant doesn't have to show prejudice. That doesn't mean that 3 and 4 don't come into the picture, and it certainly never means that you don't always look at all the factors and make a case-by-case determination. And we would say, when you look at all the factors here, defendant certainly was not denied due process of law. We ask that you affirm. Thank you.
Thank you. There were so many good questions asked during that, and the answers were repeatedly, we don't know, we don't know, the record doesn't show, we don't know about any communications, we don't know what these investigations are about. It was their burden to prove good cause, and we just don't know because they didn't meet their burden.
Well, presumably some amount of time is understandable, given the pendency of the federal action, right? The federal investigation.
Some amount of time, but it's their burden to explain what amount of time. In the papers below, there's reference that in May 2014, they learned that the federal prosecutors weren't able to bring an indictment along with the gun indictment. Sounds like at the very least, at the point at which they actually indicted Mr. Serrano on the gun charges in federal court, they knew they didn't have a federal nexus, and yet they didn't do anything because there was no communication. There was no looking into it at all. Maybe it was a month afterwards. These hypothetical, he knows some guy named Killa in some unknown state, and so maybe there's an interstate nexus with a robbery. It's pure conjecture. They may have figured it out quite quickly. Thank you.
Draper Realty versus Pizzamente.
Good afternoon, Your Honors. If it may please the court, Jimmy Wagner for the appellant defendant, Christopher Pizzamente. Your Honors, this case relies on the exercise of discretion by the lower court judge. The lower court judge refused to let me amend the answer when we pointed out that
Counsel, the guarantee says that all defenses are waived. If all defenses are waived and you are trying to amend the answer to assert a defense that has been waived by the terms of the guarantee, what is improper in the court not allowing the amendment?
Well, number one is that wasn't the position that the lower court took. The lower court took this collateral estoppel position from a separate index number that was never briefed by any of the parties. Number two is BCL 1312 is a subject matter jurisdiction statute. The statute clearly states that the court does not have the authority to issue a judgment when the underlying foreign corporation is unauthorized to do business in the state of New York.
What if we said that means when all defenses are waived except payment? How has our court interpreted that provision? Doesn't that mean all defenses are waived except payment?
So subject matter jurisdiction of the court can't be waived. They could have brought the case in California. They could have brought the case in Nevada.
But it's
This
still a
court,
defense that he waived by signing the guarantee.
no, it's not a defense for the client. BCL 1312 limits the court's ability to issue a judgment. It has nothing to do with the defendant himself.
Clearly no one, the courts included, can waive subject matter jurisdiction defense. So I think the real question is BCL 1312A a subject matter jurisdiction type defense?
And if I was given the opportunity to amend the answer,
You can answer that in rebuttal. Thank you.
May it please the court, for the respondent, Nativ Winiarski from the law firm of Cook and Marino, Winiarski and Bittens, addressing this issue of the guarantee. Justice Kern, you're correct. There's a waiver of all defenses in the guarantee.
What about his argument that it's a subject matter issue? which
So,
can't be
Justice Kennedy, you served on the bench in the case of Padrinosdis versus Agricola, 210 AD 3rd, 585, in which this court held, contrary to defendant's claim, the defense of lack of standing does not implicate subject matter jurisdiction, hence it can be waived.
1312A is not a standing defense, it's a capacity defense. Capacity as it's been styled in your brief, but is that particular statute a subject matter jurisdiction type requirement?
So if we're going to frame it as a capacity defense, I draw Justice Hagan's attention to Security PAC versus Evans, 31 AD.
Again, that's a standing in a foreclosure situation. That's capacity. That case had nothing to do with BCL 1312A. I'm talking specifically about 1312A.
I understand. And in that case, they specifically said objections to the status of a corporation, which is exactly what BCL 1312 is. The objections to the status of a corporate plaintiff have been interpreted by courts as being based on legal capacity to sue. The issue of lack of capacity does not implicate the jurisdiction of the court. It's merely a ground for dismissal if timely raises defense, which didn't happen in this instance, and therefore it was raised, especially considering the fact that it was more than 2 years after the complaint was interposed, to say nothing of the fact that we weren't able to correct it because the day before they made the cross motion and the Al Horno action, they specifically registered this corporation so that we wouldn't be able to correct it.
Thank you.
let's go back to the complaint. What everyone's missing here is the plaintiff lied in the complaint, then the plaintiff lied again on summary judgment affidavit.
That still doesn't affect your waiver in the guarantee.
It absolutely, it affects my ability to amend the answer. If we're gonna let parties lie in the complaint and say they have the authority to do business in the state of New York when they do not, and they know they do not, this is a very limited issue. Should defendant been permitted to amend his complaint? The CPL law says it should be freely granted. Then, once I amend the complaint, we can come back here on all these different issues and have these discussions.
We test the merits all the time on a motion to amend.
I'm sorry.
We test the merits all the time on a motion to amend.
On the motion to amend on the 3025,
If
what
there's
we
no
don't...
merit whatsoever, then we don't allow the motion to amend. That's the law.
No, under 3025, the motion to amend should be freely granted. What happened here is we have a plaintiff who lied.
Thank you. Thank you. Since you wanted to have limited time and argue them separately, that's what we'll do. Realty versus Al Horno.
Again, Jim Wagner, the appellant for Al Horno. And lying just seems to be the substance of this plaintiff's position. Because let's look here. Here I'm forced to go to an inquest on damages. At inquest, what's produced? A copy. I object. I demand the best evidence. The witness turns around and I ask the witness, why do you not have the original with you? He states, no one told me to bring it. Here we are in the first apartment. An appellant is now trying to argue what was presented at the.
Did you ever dispute the contents? Because I didn't see that there was a dispute about the contents of the lease.
There was a dispute about the contents. It was disputed in my answer. Number two is I don't know the original to dispute it. They never produced it at the inquest. What they produced was a copy. It was an admitted copy. They later call it an original copy for whatever that's worth. But when Judge Bannon denied summary judgment, granted them liability, they were required to come to court and prove damages. To prove damages in this landlord-tenant action, they needed to have the original lease. What they did not have at trial was the original lease. On the best evidence, they should have explained why they didn't have the original lease. What the witness says is, no one told me to bring it. Plaintiffs then attempt to pivot and say, we're going to bring this in under a business exception rule. Because it is hearsay, we all acknowledge it's hearsay, but instead of even attempting to use the business records rule, they don't have the correct witness. The witness testified he has never seen the original, he couldn't even authenticate the signatures. In addition to not being able to authenticate the signatures, all the information provided by the witness was hearsay from his employer. He had no direct knowledge.
Counsel, you just mentioned the best evidence rule. Don't we only look to that if the contents of the writing is in dispute? And here we don't have a dispute.
In my answer, the contents of the writing were in dispute.
Thank you.
So, Justice Kern and Justice Michael, you stated that there was no dispute as to the contents of the document. In fact, we put the lease in the motion for summary judgment. It was never objected to. To the contrary, when they opposed it, they specifically cited to the provisions of the lease. That's in page 239 of the record, where you can see that they admitted to the terms of the lease.
I also pointed out that he didn't dispute the contents as well.
There was no dispute as to the contents, and it was in the motions. We cited to the Shudry case where the court says if it's in the motions and there's no dispute, it's an admission. I also note from the transcript that the witness was quite clear. This is page 300 of the record. Is the document the original lease you had in the file? Answer, yes, it is. And it's again also in 305 of the record. Do you have the original of this lease in your office? It looks like we have it here. So you're saying you don't have the original in your office? The original is here. It was produced at the inquest. In fact, the referee at the inquest said, I see Ray's signatures. And what she then said is she goes, well, even if this isn't original, you can always introduce a copy because there was no dispute as to the document itself. The two cases cited by the lower court, one is Yorkville Towers, in which Justice Gesman, Justice Kern, you were on that bench. We had a witness here, which was the CFO of the company, who was fully familiar with the records, who was fully familiar with how they are kept in the office, that they were business records, and decision after decision from this court, whether it's Yorkville, whether it's the De Leon case or others, all specifically say that's certainly sufficient for purposes of introduction of both the lease and the rent ledger.
Thank you very much.
And as stated, counsel sat here before this bench and stated a piece of evidence is even original or it's not. I'm going to remind this court it was.
Counsel, do you agree that when the lease was proffered on plaintiff's motion for summary judgment that you didn't object to it in any way?
I did not object to it on the motion for summary judgment. The lease
So you
profit.
didn't object to either the authenticity or the contents of the document which the plaintiffs proffered as the lease?
Yeah, I just said I didn't object because the lease profit at the inquest was different than the one profit on summary judgment. And that's referenced by the referee in footnote 5. Furthermore, the Court of Appeals, and I think it's November 24th, November 25th, on Knight versus New York and Presbyterian Hospital, actually upheld this court in reference to the authenticating of a document. And what happened here at this inquest is this witness flat out said, I cannot authenticate these signatures. I wasn't there when they signed it. I have no idea who signed this document. Thank you.
Landel versus LifeBridge Dental.
Good afternoon, Stephen Bergstein for the plaintiff appellant. After the plaintiff repeatedly objected to unsanitary practices at the dental office where she was working, rather than take her complaint seriously, she was transferred to a different location where her new supervisor greeted her and essentially told her to cut out further whistleblowing. No drama here. I don't want any issues here. Making it clear to plaintiff that she was transferred for purposes of keeping her mouth shut. Then what followed was a series.
Request a transfer?
She requested a transfer, but not to this place. She requested a transfer to different locations, but they sent her to Grand Central, where she's met with a general manager who immediately tells her in sum and substance, no more whistleblowing from you. No more.
Did that statement or anything that happened there change her pay, change her work obligations?
No, but it would dissuade her from speaking out further on additional whistleblower allegations, which is the standard. The standard is not whether she loses money or is demoted. The standard is whether management's response to her whistleblowing would dissuade her from further whistleblowing, and that's a pretty settled principle under retaliation law. Some other principles that are relevant to this case is we look at the totality of the various adverse actions that the plaintiff was subjected to. We don't look at them in isolation. So in the aggregate, if they would dissuade an employee or alter the job conditions for the worse, that's an adverse action for purposes of bringing a case like this. So on the first day, as I mentioned, she's essentially told no more whistleblowing. The next day, she finds that she's not being assigned any work. So this is day 2 of her new employment relationship at the Grand Central location.
When she brought that to her supervisor's attention or to time and leave, whoever, however you reference them, that issue was resolved, right?
Correct, but it's further signal that she's going to be a second-class citizen in this workplace. I mean, day 2, you're already met with this kind of unusual hostility that most employees are not met with when they're transferred. She's also falsely written up for taking a sick day. They referred to it as an unexcused absence. That wasn't true. She was written up in bad faith for coming in late. Under the company's policies, you get a verbal warning. This is all happening within really a 4-week period. She's yelled at for making a phone call, singled out for this. Her supervisor says to the plaintiff, you disgust me. I can't even look at your face. All of this supports the inference, and this is a Rule 3211 posture, that in retaliation for her whistleblowing, they took action intended to dissuade her from speaking out again about the unsanitary dental practices in her workplace. And so the Supreme Court's analysis was, well, she was transferred, but she didn't lose any money, and, she had requested a transfer anyway. That's looking at matters from defendants' standpoint. It doesn't look at matters from the plaintiff's standpoint. The standard for adverse actions in a retaliation case are relatively lenient in cases like this because you don't have to show loss of pay or a demotion. You only have to show actions taken to dissuade. What employee under circumstances like this is going to speak up again about unsanitary practices? And it's an objective standard, not a subjective standard. So we really need discovery to flesh all this out. I don't know how the defendant really can get around the comments made to the plaintiff on the first day about we don't do drama here. I don't want any issues here. We know what she's referring to. It was 10 days after she spoke out.
We don't know that supervisor doesn't say that whenever she gets a new employee, right?
That's an argument they can make to the jury, but it's a heck of a way to greet a new employee 10 days after she created drama at her last workplace. Welcome to Grand Central. We don't do drama here, and we don't want issues here. And she looked at the plaintiff when she said it at a staff meeting. The inference is not here. You're not going to be speaking up here. You did it there. You're not doing here. That's going to dissuade. Thank you.
Thank you. May it please the court, David Greenhouse, Jackson Lewis for the respondent. Your Honors, this court should affirm Thank you. The trial court's decision dismissing appellant's complaint. As the United States Supreme Court has said, as the lower courts here in New York have said, as any court and every court who's observed, who has commented on this issue has observed, Title VII and its analogous local and state anti-retaliation statutes are not civility codes. Courts are not superhuman resources departments designed to mediate garden variety employment disputes. The statutes are designed, including Section 740 and Section 741 of the labor law that are implicated here, are designed only to protect employees against unlawful retaliation. In order to plead unlawful retaliation, a plaintiff must properly allege an adverse employment action. In other words, if something happened to that person, to that employee, that would dissuade a similarly situated worker from making a similar complaint, whatever that complaint was. The trial court here correctly determined that the plaintiff had not met that burden and correctly dismissed the complaint. The cases upon which respondent relied on at the lower court and relies on here at the appellate division are all almost directly on point with respect to the kind and quality of appellant's allegations with respect to adverse employment actions. Silvis against City of New York, a lateral transfer is not an adverse employment action, especially here. Appellant asked for a transfer. There are no allegations that she was unhappy with the transfer at the outset. There are no allegations that there were space at any of the other facilities that she should have been transferred to. Mockru against Comprehensive Care. Failing to stop a plaintiff from being mocked is not retaliatory conduct pursuant to 740 and 741. King against New York City Health and Hospitals, affirmed by the First Department. Plaintiff was transferred, her schedule changed, she was excluded from meetings, coworkers and supervisors were hostile to her. The court held that those all were not adverse employment actions. The authority on which appellant relies, all are circumstances that are far more egregious set of circumstances. Hicks versus Baines, the primary case upon which appellant relies. And number one, in that case, Second Circuit, Title VII does not set forth the general civility code for the American workplace. Petty slights and minor annoyances that often take place are not actionable retaliation. There, the defendant sabotaged the plaintiff's work. He was disciplined. His days and hours were changed. He was required to work alone. He was assigned to work in a dangerous juvenile detention facility. And the employees there conspired against him to fabricate charges against him. I mean, that's not what appellant is alleging here. What appellant is alleging here is the epitome of a garden variety, of a minor annoyance that happens all the time in the workplace. It is not protected activity, and it's not actionable retaliation.
Thank you.
A minor annoyance that happens all the time in the workplace. I know of no case like this where in immediate response to your whistleblowing, you're told by a supervisor, essentially, no more whistleblowing. That by itself would dissuade a reasonable employee from speaking up again, right? You wouldn't take a chance in risking your job after you violate a direct order like this, and you're told that on a couple of occasions, and then the next day, you come in, the next day after your first day of work, you're not assigned any work. You have to request, put me back on the schedule, what's going on here? If you look at each one in isolation, you could say, well, that's a petty slight, but we look at the aggregate. We look at the aggregate, and over a 5-week period, there's 4 or 5 examples of hostile actions by management for no apparent good reason. For no apparent.
Put on the schedule when she complained, right?
Yes, but what's going on? You start a new position at a new place, and you're immediately not given work. So in a tight timeline, you have 4 or 5 hostile acts for no apparent purpose.
Thank you.
Thank you.
Seaman versus City of New York.
It's Marx.
Oh, I'm sorry, Marx versus City of New York. What? You knew who you were. You know we were calling you.
Good afternoon, Your Honors. May it please the court, my name is John Scola. I'm here on behalf of appellant Ernesto Marx. Officer Marx was a former NYPD officer who was terminated after he was found guilty of assaulting an ex-girlfriend and then violating an order of protection. as noted in our papers, he could not have committed this crime because he was at church while it happened. If you take the statements of the alleged victim, the earliest this assault could have occurred was at 7:02 on June 7th of 2018. My client.
The findings in the underlying proceeding is that this assault happened prior to him getting to church. Why is it that that's inaccurate, or why should we reverse that?
So that's not my interpretation of what happened. If you look at page 12 of our original brief, the hearing officer notes that the complainant arrives at her building at 7:02, where she finds the petitioner sitting on the front steps. Thereafter, it's alleged that the assault happened. He was at church at that time. That's what is in the record. If there's an allegation that
Counsel, this is really all about credibility determination. So why would we not defer to the credibility, determinations? You have the victim here who testified about what happened. You have the photos, that align with, the injury. So why is that not sufficient?
Because the victim didn't testify. The victim allegedly gave a statement on the incident.
Okay, statement. All right, it's late.
Well, that's very important, Your Honor. The reason why is because that record was sealed when the criminal case was dismissed. When that case is sealed, it cannot be inserted into a proceeding without an unsealing order. That never happened. That's in direct violation of Executive Law 296 and the sealing standards of 16050 and 16060. That never happened. The testimony that was elicited in the trial came from an officer that took the alleged report on the date of the incident. None of this is admissible in this proceeding. Once that criminal case is sealed, there needs to be an unsealing application, and that needs to be unsealed in order to be elicited in this proceeding. Notwithstanding that, the defendants admit that this was brought because of the dismissed criminal case. You cannot prosecute civilians or officers or anybody for a criminal case that is resolved in their favor. That is facially discriminatory. The defendants admit that's the basis of the prosecution herein in their answer.
No, the basis of the prosecution was him allegedly violating the rules, regulations, and code of conduct of the NYPD.
That's what the defendants, the respondents make an argument in this appeal. However, in the pleadings of plaintiff in the Supreme Court, the defendants admit that this was brought based on the criminal case that was resolved in favor of the plaintiff.
Wasn't there consent? So I know I'm not losing it. There was testimony. Yeah, I'm not losing it. There was testimony. You consented to the admission of the transcripts and the photos.
Your Honor, no. There was testimony from officers in the proceeding, yes. That we can't consent to something that they need. They had the records improperly, illegally, against the law. At trial, they held up the records, and whether or not they consented to them or not doesn't violate or doesn't rectify his violation of his rights.
Thank you.
We'll address the rest on reply.
Good afternoon, Tahir Sadri, appearing on behalf of the City of New York. To respond to my colleague's statements, all of the exhibits that were admitted into evidence, other than the photographs, were admitted on consent. And so, any issues that are raised as to the propriety of those documents being admitted into evidence is beyond the jurisdiction of this court at this time. With respect to the photographs, the objection was to foundation. No issue was raised that these photographs ought to have been sealed. With respect to the GPS records, I think the hearing officer made a determination that the records were not reliable, and it is the city's position that that wasn't an abuse of discretion. But even if it was, that would not require this court to discredit the entire, former girlfriend's entire account of this incident happening. It was entirely possible to credit her account, but yet find that she erred somewhat in her estimation of the time that that it occurred and that it occurred somewhat earlier. And these GPS records show Marx being at home for some 3.5 hours. The incident that's alleged is a very brief one. She said that he strangled her for approximately 5 seconds. And so it's entirely possible for Marx to have either turned off his phone or left the phone at home and gone to the ex-girlfriend's and then gone to the church and the choir practice thereafter. Otherwise, this is, I mean, with respect to these two, with respect to the assault and the violation of the order of protection, these are really entirely issues of credibility that are largely unreviewable and that find a lot of support in the record. And so therefore, there's no basis for disturbing them. With respect to all of the other specifications, petitioner does not raise any meaningful objection to them. Meaningful, he objects, but he doesn't meaningful basis for overturning them. So the city requests that the court confirm the determination of the police commissioner. Thank you.
I would just like to add that the hearing officer, the one that found that my client was guilty, specified that the assault happened after Santos returned to her home at 7:02. This is on page A1689. So all these arguments that this happened earlier is not relevant to this case. My client presented evidence and a Supreme Court justice's sworn affidavit that he was at choir practice from 7 to 9 p.m. That's when the incident took place. If it took place earlier, it's not in the order. It's not in the report. That's an argument they could have made at trial. The fact remains the alleged victim here threatened my client's career an hour before this allegedly happened and never testified at trial. They use sealed records. You can't violate my client's constitutional rights to have a criminal case adjudicated in his favor and not have negative actions taken as a result of that victory. That's what happened here. The NYPD falsely arrested my client. When he won the case, they ended his career. That's what happened.